This matter before the Public Regulation Commission will please come to order. This is the time and place set for the evidentiary hearing in the matter of Public Service Company of New Mexico's application to approve its triennial 2024 to 2026 Energy Efficiency Program Plan and associated relief, which is docketed as case number 23-00138-UT. Good morning. My name is Anthony Medeiros. I and Robert Lundin, Associate General Counsel for the Commission, were recently assigned by the Commission to preside over this matter due to the retirement of the formerly assigned hearing examiner, Michael Smith. I know I speak for many of the parties to this proceeding that Mr. Smith will be greatly missed at the Commission, but we wish him only the best in this next stage of his life and endeavors. I'd like to start today with appearances of counsel for the parties, starting with PNM. Who appears for Public Service Company of New Mexico?
Good morning, Mr. Hearing Examiner John Verheuel for Public Service Company of New Mexico.
Good morning, Mr. Verheuel. Who appears for the Attorney General, the Office of the Attorney General of the State of New Mexico?
Gideon Elliott for the Attorney General's Office.
Morning, Mr. Elliott.
Good morning.
Who appears for the Coalition for Clean, Affordable Energy?
Morning, Mr. Hearing Examiner Charles DeSalen on behalf of Coalition for Clean, Affordable Energy.
Good morning, Mr. DeSalen. Who appears for Western Resource Advocates?
Sydney Beatles appears for Western Resource Advocates. Good morning, Mr. Medeiros, Mr. Lundin, and colleagues.
Good morning, Ms. Beatles. And finally, for the Commission's Utility Division staff, who appears?
Thank you, Mr. Hearing Examiner. Appearing on behalf of Utility Division staff, I'm Bradford Borman. I am joined by my co-counsel in this case, Ryan Friedman, and our two witnesses are also present, Mark Tupler and Agatha Malik.
Great. Good morning, staff members, and Mr. Borman, of course. The record should reflect that 3 intervener parties contacted the hearing examiners before the hearing via email, requesting that they be excused from attending the hearing. Those interveners, Bernalillo County, New Mexico Affordable Reliable Energy Alliance, and Albuquerque Bernalillo County Water Utility Authority, were granted excusal from the hearing, subject to the procedural rules proviso that they are, quote, deemed to have notice of and waived their right to object to all matters addressed, resolved, or determined in their absence, end quote. Per 1.2.232B NMAC. Now for preliminary matters before we go to public comment, if we have any public comment. I, as suggested in the October 13, 2023 pre-hearing order, when counsel are about to begin their cross-examinations of a particular witness, that counsel will be asked to provide an estimate of the amount of cross-examination time counsel has for that particular witness. In order to conduct an orderly, efficient hearing, counsel will be held to that estimate as indicated in the Zoom timer app appearing in my little Zoom panel. This is consistent with the procedural order, with the procedure actually counsel are familiar with, given its more elaborate application in last month's PNM rate case hearings in case number 22-00270-UT. I say more elaborate application because the difference here is that a pre-hearing conference to establish, among other things, the cross-examination times was deemed not necessary and thus was not held. Okay, with that, do council have any other preliminary matters to address before we move to public comment? Okay, I believe we may have some public commenters to add, if Ms. Kippenbrock, if you're there. Ms. Kippenbrock? We had we had at least a couple of people who had signed up to do to provide public comment, but they may have gotten lost in the switch, unfortunately, to the new hearing. So we will, if you're listening out on Zoom, please call or contact Anna Kippenbrock to reestablish a connection to this Zoom hearing, and we'll provide for public comment sometime soon in between one of the witnesses testifying during the proceeding. You'll have your opportunity to provide public comment, those folks who did sign up for public comment. But in the meantime, let's proceed. Let's proceed to the presentation of evidence pursuant to 1.2.233B NMAC. And I'm pausing because I'm looking to see if anybody does come on to give public comment. Okay. Pursuant to 1.2.233B NMAC, the order of presentation receipt of evidence will start with the applicant, Public Service Company of New Mexico, and then we'll work out the presentation after that. So with that, with the applicant PNM, please call its first witness. Mr. Vigil, would you please call for your first witness?
Yes, PNM calls Sharon James.
Okay.
Ms. James, would you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Good morning, Ms. James. Please state your name and job title.
My name is Sharon James. I'm the manager of energy efficiency at PNM.
Do you have before you what's been labeled PNM Exhibit 2?
Yes.
What is that?
It is my direct testimony.
Was this prepared by you or under your supervision?
Yes, it was.
Is it a true and accurate account to the best of your knowledge?
Yes, it is.
Are there any additions or corrections to it?
No, no corrections, no additional corrections, except for the ones made by notice of errata on September the 29th.
Okay, taking into consideration the corrections in that notice of errata, if I asked you the same questions today, would the answers be the same?
Yes.
Mr. Hearing Examiner, at this time, I move to admit PNM Exhibit 2, the direct testimony of Sharon James.
Is there any objection? PNM Exhibit 2 is admitted.
Ms. James, do you have before you what has been labeled PNM Exhibit 3?
Yes, I do.
What is that?
My rebuttal testimony.
Was this prepared by you or under your supervision?
Yes, it was.
Is it a true and accurate account to the best of your knowledge?
Yes, it is.
Are there any additions or corrections to it?
No, there are not.
If I asked you the same questions today, would the answers be the same?
Yes, they would.
Mr. Hearing Examiner, at this time, I would move to admit PNM Exhibit 3, the rebuttal testimony of Sharon James.
Is there any objection? PNM Exhibit 3 is admitted.
Mr. Hearing Examiner, before I offer the witness for cross-examination, we filed our application in this matter and we submitted it as PNM Exhibit 1. Would you like it admitted into the record? If so, I would do so via Ms. James.
Yes, let's go ahead and admit it.
Okay, Ms. James, do you have with you what's been labeled PNM Exhibit 1?
Yes, I do.
What is that?
The application.
Was this prepared by you or under your supervision?
Yes, it was.
Is it a true and accurate account to the best of your knowledge?
Yes, it is.
Taking into account the notice of errata, are there any additions or corrections to it?
No, there are not.
I'm going to skip the question on asking you the same questions today because there were no questions in the application. Mr. Hearing Examiner, at this time, I would move to admit PNM Exhibit 1, our application.
Any objection? Hearing none, PNM Exhibit 1 is admitted.
I offer the witness for cross-examination.
Thank you, Mr. Vigil. Now, we didn't set a cross-examination order. Who, are the parties agreed on one? Then I'll just go down the list and of what I used as alphabetical order, starting with the Attorney General. Mr. Elliott, do you have any questions for Ms. James?
I do, Mr. Hearing Examiner. I would ask for 25 minutes. I hope not to use it, but I think that would be sufficient.
Okay, please proceed.
Good morning, Ms. James.
Good morning, Mr. Elliott.
It's nice to meet you. I don't think we've had the pleasure of speaking before.
It's nice to meet you as well.
Ms. James, I'm going to jump right into your testimony, your rebuttal testimony on page 7. Do you have that?
I do.
Okay. This is where I'm starting, I guess, just looking here. This is under section 2, which starts on page 6, where you're discussing the Mr. Takahashi, the NMAG's witness's testimony. And on page 7, let me just see here. Yes, starting at line 16.
Okay.
You say the non-monetary and or non-specific benefits that Mr. Takahashi includes in table 5 would be difficult or impossible to quantify and have not been utilized as UCT calculations in previous filings to measure cost effectiveness. I have 2 questions related to this. Has PNM investigated whether those benefits, has PNM actually investigated whether those benefits are impossible or difficult to include or quantify?
No, we have not. I would say, though, that any benefits included in our avoided energy and demand costs that are implicitly included would be better described by witness Phillips.
Okay, so just say that again for me. The ones that are not explicitly included, but implicitly included might be better discussed by Mr. Phillips. Is that correct?
That is correct.
Okay. I hope he doesn't direct us back to you, as my time would be lost. Let me just move on to my second question, which is.
Well, Mr. Elliott, we're not going to play that game.
Okay.
I was privy to some of the communications that I shouldn't have seen about the rulemaking, about some parties playing hot potato with questions. And I will exercise my discretion to recall a witness
Okay.
if we start seeing that game being played. I'm not suggesting it is, Ms. James, at all, but just for those of you out there listening, hopefully carefully. Go ahead, Mr. Elliott.
Thank you. Are you familiar with the National Standard Practice Manual for assessing cost effectiveness of energy efficiency resources?
Yes, I am.
Okay. Is PNM planning on investigating any of the missing electric system benefits that Mr. Takahashi identified?
We are open to discussions about alternative methodologies. outside of this proceeding with other utilities that may also be impacted by the cost benefit analysis and any additional benefits that might be desired.
Okay. I'm going to jump around now I just want to discuss with you briefly the federal programs that you mentioned on page 18 of your rebuttal. Let me know when you're there.
Hey, sir, I'm there.
Okay. So on page 18, lines 21, beginning at line 21, will PNM add information to educate customers about important federal and state funding opportunities to home energy reports, as CCA witness Kenny recommends? My question is PNM providing it? Does PNM plan to provide information on federal incentives and IRA programs only through the Home Energy Reports program?
No, we are also providing information on our website, on our PNM website, as well as through our commercial program, through training our trade allies, also through our home energy checkup program. We're including that in the assessment reports as well, and through our new home construction and midstream programs.
Okay, thank you for that. So regarding the federal incentives, can you tell me, well, let's turn to page 13. So on page 13, let me just see where you say this. Okay, at the very line 22. So this is in regard to the question whether it'd be worthwhile for PNM to file an updated version of its EE plan to include the incentives. And you say at line 22, PNM energy efficiency programs are separate and should be designed and cost effectively managed independently from federal incentives. My question is, PNM energy efficiency, can you explain what this means to have the programs separately designed and cost effectively managed?
Certainly. So our programs are recovered through a rate rider. And so the programs that we design, we believe are meant to complement any other federal or state incentives. Given the fact that our incentives are recovered through rate rider and paid for through customer bills, we are certainly happy to promote all of the federal and state incentives. And we believe that it's important that customers know about these incentives, but we need to manage our programs according to the EU EA.
Okay. So I suppose working backwards here, if we could turn to page 10 of your rebuttal. And this is where, just starting at page line 5, regarding customer participation. So here you say that the program needs to provide every affected customer class with the opportunity to participate and benefit economically. Can you explain how you understand the term benefit economically?
We strive to ensure that all of our customers have an opportunity to participate in our programs, from residential customers to low-income customers to commercial customers. And we design our programs tailored to those segments.
So certainly I would understand enrollment in the program, and but to participate economically, does that infer in your mind a specific benefit of participation?
Yes, I believe so. One example would be our small business customers. They do not have a lot of capital to spend, so we ensure that our incentives are maxed out for them to be able to have a return within a year of the investments that are made through energy efficiency.
Okay. I'm just going to move on to page 11. This is where you're discussing collection of customer data. Starting at line 7. You say that PNM collects, tracks, and verifies all the participation data provided by the third-party implementers on a regular basis. My question is, does PNM collect customer data on the total cost of energy efficiency measures, such as the total cost of installation, labor, and equipment for heat pumps?
No, we do not.
Is it able to collect it?
No, our implementers do not collect that data. When we were utilizing the TRC cost effectiveness test.
I'm sorry to interrupt you. What is TRC?
The total resource cost test.
Thank you.
We were able to collect data then to adhere to that particular cost test. But with the UCT, we primarily collect data related to the measure, the efficiency tier, the incentive related to that measure, and participation data in terms of customers.
So your ability to collect the data is based on the type of test that's being applied?
Correct.
And why is that?
Because we feel it aligns to the requirements of the EUEA in terms of energy savings goals and remaining cost effective.
So it's a client requirement, not necessarily a limitation of the vendor.
It is how we have conducted business in relation to the UCT model and our goals related to energy savings.
Okay. Moving on to page 14. This is a discussion of heat pumps. And you note that heat pumps are included in the program. And my question is, does the pilot offer incentives for adopting cold climate heat pumps?
Yes.
Okay. And how are those, how's the use of the cold heat pumps? How will those savings be captured?
They will be captured similarly to the other measures that are included in the program.
Okay. Because I was looking at page 21, page 20 to 21. And you note that PNM's implementer, I'm looking for where you start this. Right, it's at the end of line 21 of page 20. You note that PNM's implementer does not have the capability to collect summer and winter peak hourly demand and sub-hourly data for households with electric resistance backup heat. So I just want to make sure how I understand how the vendor or implementer will capture the data. Is that a limitation?
Could you please restate the question?
Is the implementer's limitation on collecting summer and winter peak hourly demand, does that in any way prevent assessing the benefits of electric heat pumps, specifically cold weather heat pumps?
No, I don't believe so, because again, we are tracking this data against our goals related to energy savings. And so anything related to electrification would be outside of that.
Okay. Moving on to the electrification pilot for low-income customers. It's a simple question, but the all-electric homes pilot, does that include manufactured homes?
No, the all-electric does not include manufactured.
Okay, so that means it also does not include existing manufactured homes. Is that right?
No, as far as I know, it does not.
Okay. I have no further questions, Ms. James. Thank you for your time this morning.
Thank you.
Thank you, Mr. Elliott. I had texted Ms. Kippenbrock to find out if we had the public commenters now, but I haven't received a message back from her responding that they're available. So let's move to the next cross-examination of Ms. James, and that would be Mr. DeSalen for CCAE. Mr. DeSalen?
Thank you, Mr. Hearing Examiner. I have no questions for the witness.
Okay, thank you, sir. Ms. Beatles?
Yes, thank you, Mr. Hearing Examiner. I may have up to 20 minutes of cross-examination from Ms. James.
Okay, please proceed.
Thank you. Good morning, Ms. James.
Good morning, Ms. Beatles.
Do you agree that homes with electric heat resistance typically have a higher winter peak demand than a home that does not?
I do not know the answer to that, Ms. Beatles.
would you agree that a home with cold climate heat pump typically has a lower peak winter demand than a home with electric resistance heat?
Again, I do not know the answer to that.
Do you agree that weatherization measures can reduce cooling needs?
Yes, I agree.
And would you agree that the same weatherization measures can therefore reduce winter peak demand?
Again, I do not know that in terms of winter peak demand.
Do you agree that a household's peak demand is an important factor in determining distribution system upgrade needs?
Again, I do not know the answer to that in terms of how it relates to energy efficiency.
If PNM's advanced metering infrastructure, otherwise referred to as AMI, for purposes of the record, if PNM's AMI proposal is approved by the commission, do you agree that PNM will have data on households' load on an hourly and sub-hourly basis?
As far as I know, that case is pending, so I cannot speak to that.
Do you know whether advanced meters have the capability to collect data on a household's electric load on an hourly and sub-hourly basis?
Objection.
I do not know that answer, Ms. Beatles.
Mr. Medeiros, if you're speaking, you're muted. I apologize, Ms. Beatles.
Right.
There you are.
Hold on just a second. My decided to glitch out too. Can you hear me?
Yes.
All right, let's try it this way until I can get my head work. Did we have an objection?
We did, Mr. Hearing Examiner. The questions are not only outside the scope of Ms. James' testimony, but they're outside the scope of this hearing. Ms. Beatles is asking about advanced metering infrastructure, which is a matter that's pending in a different docket.
Can you, Ms. Beatles, please respond?
Well, I believe that the details of electric load used by customers would be relevant to the energy savings requirements of the Efficient Use of Energy Act. So I think it's reasonable to explore this witness's knowledge of the data that can be collected by advanced meters.
And if she should just give her answer then. Oh, the objection is overruled. Ms. James, answer to the best of your ability, please.
I believe that there will be benefits with AMI that may be realized, but I cannot speak to what those might look like.
And my question was not about the benefits per se. I just was asking about whether these advanced meters will have the ability to collect data, the capability to collect data on a household's electric load on an hourly and sub-hourly basis, and just whether you know what. And my question is, if you know whether these meters have that capability.
I do not know if they have that capability.
If a new home is constructed after, well, assuming that PNM's AMI proposal is approved and for new homes that are constructed afterwards, would you expect that the new homes would have advanced meters installed?
Again, I don't know, possibly. I can't be certain of that.
Do you agree that, are you familiar with the Inflation Reduction Act?
Yes, I am.
Do you agree that federal incentives provided through that act are expected to drive faster adoption of heat pumps and heat pump water heaters?
I believe that that's safe to say that those incentives will encourage customers to adopt those technologies. Yes.
And are you aware that the Environmental Protection Agency has proposed to remove the Energy Star designation from central air conditioning units and gas furnaces starting in 2025?
No, I was not aware of that.
Do you have any reason to disagree, or do you have any basis on which to disagree with that representation?
No, I do not.
So would you expect heat pump incentives to lead to increased deployment of heat pumps and heat pump water heaters in your service area?
I believe that market transformation takes a steady approach, and we have a high low-income population in our service area. So it's important to ensure that the transformation is lasting, and patience and perseverance towards encouraging these technologies.
And would having data on household data on peak demand associated with heat pumps enable PNM to plan for widespread adoption of heat pumps?
Could you repeat the question, please?
Yes, let me try that. Let me try that again. Would having data on households with heat pumps peak demands enable PNM to plan for widespread adoption of heat pumps?
I can only speak from an energy efficiency perspective. In terms of efficiency, I believe so.
And would having data on the peak demands associated with heat pumps enable PNM to plan for potential impacts on the distribution grid?
That would be outside of my scope of knowledge in terms of the distribution system.
Thank you. I may ask Mr. Phillips of that question, about that question then. Are you aware that New Mexico is part of the U.S. Climate Alliance?
Yes, I am.
Are you aware that members of the U.S. Climate Alliance just announced a commitment to quadruple heat pump installations by 2030?
No, I was not aware of that.
Does PNM strive to align its program offerings with state policy?
PNM is currently aligning our goals and our objectives and our programs to meet the Efficient Use of Energy Act. And anything beyond that we support, but that is our core goal in terms of our programs and what we need to achieve.
And generally speaking, would you agree that higher incentive levels will likely lead to higher adoption rates?
I do agree. And I will also emphasize again that it takes a steady approach to make market changes. But yes, I do agree. And we plan on increasing incentives for heat pumps.
So on page 21, of your rebuttal, you refer to grid-enabled heat pumps. Is that correct?
That is correct.
And just for the record, could you explain the difference between a grid-enabled heat pump water heater and one that is not?
It would allow for demand response and load control.
And are you aware that Excel Energy Company in Colorado provides a higher incentive to customers for the installation of grid-enabled heat pump water heaters?
No, I was not aware of that.
Mhm. And on lines 8 through 10 of that page 21 of your rebuttal, you state that incentives would need to be offered to the builder customers for the incremental cost of the product and for connecting to the grid, which is not within the current scope of this program. Do you see that?
Yes, I do.
And would you agree that the commission has the authority to add a higher incentive for grid-enabled would you agree that the commission has the authority to add a higher incentive for grid-enabled heat pump water heaters to your program?
Objection.
Please state the basis of the objection.
It calls for a legal conclusion.
Ms. Beatles?
In my experience, experts generally have a working understanding of the regulatory authority of the commission. So I am asking for her opinion, not as a lawyer, but as a utility expert.
Overruled.
Should I restate my question, Mr. Medeiros?
If Ms. James needs it, yes. Ms. James?
Yes, please.
Okay. Would you agree that the commission has the authority to add to your current program a slightly higher incentive for grid-enabled heat pump water heaters?
Yes, I believe that the commission does have authority to make those decisions.
Okay, thank you. Ms. James, Mr. Hearing Examiner, I have no further questions.
Thank you, Ms. Beatles. Let's see, staff, is Mr. Borman, is this your witness?
Staff has no questions for this witness.
Okay, thank you. I noticed you had Mr. Friedman on too. Does he have some witnesses?
No, I do
Sorry,
not.
here.
Yeah.
No, I mean for other witnesses.
Mr. Friedman will be introducing and representing one of our witnesses that go on.
Okay, Okay, thank you. Sorry about that. I wasn't clear about that. Mr. Lundin,
Yes, Mr. Hearing Examiner, I do have a few questions. Can you hear me okay?
Yes, sir.
Hi, Ms. James.
Hello.
I'm going to make you jump around a little bit, and I'm sorry for
Okay.
that. But right now I'm looking at the application at Appendix C, page 100.
See?
And it's page 100, table 42.
Is this the measurement and verification report, sir?
No, ma'am, I'm looking at the Evergreen Economics Report.
Yes, that would be the M&V.
Okay, sorry.
Okay,
Yeah, Appendix C, page 100, table 42.
I'm not seeing page 100.
It's page 96 on the Evergreen report.
96. Okay, I do see
Yeah.
96.
At the top of the page, it says page 100 of 267,
Okay.
Appendix C. Okay. So I'm looking at the Energy Smart program. Is this table showing the UCT value from 2022?
Yes, that is correct.
And from my understanding, does a lower UCT value show that a program is less successful?
Yes, it means that it is less cost effective. Yes.
Okay. Now we're going to jump again to your direct testimony at pages 11 and 12.
Okay. Okay.
And on tables 4, 5, and 6 on those pages, the budget increases for the Energy Smart program are significantly higher than for the other programs. I just wanted you to talk about that kind of generally, and maybe why the budgets were proposed to be increased so much when the program has perhaps less success.
Certainly. So this program used to only offer weatherization to single family homes, but we have since added multifamily properties to this program, and it has been pretty successful in terms of participation. So that significant increase is due to the addition of multifamily projects.
And I recall from some of the testimony that there's a major backlog for this program.
Yes, for the single family customers, there is a backlog.
Does the increased budget do anything to address the backlog?
No, it does not. It addresses the multifamily portion primarily of that program.
why
Is it
didn't
possible-
PNM add, excuse me, Mr. Lundin, may I just elaborate on that question? If there's a backlog in the non-multifamily portion, why didn't PNM boost the budget there as well?
I believe that we did increase the budget
Okay,
somewhat based on recommendations from MFA, but it was not as significant as the multifamily, as that is more expensive.
go ahead, Mr. Lundin.
Thank you, Mr. Hearing Examiner. So is it possible that we could have money left on the table if the budget's being increased and there's this big backlog that's maybe difficult to address? Is this budget going to be put to good use, is what I'm asking.
I believe so. I do agree that the backlog has been an issue, and we are willing to try to work through that to the extent that we can as a partner in the program.
And who are your partners in the program?
The New Mexico Gas Company, LIHEAP, Department of Energy.
Mr. Hearing Examiner, I'm going to move on to another topic if that's all right with you.
Oh, yeah, please do, of course.
Ms. James, I'm now looking at your rebuttal testimony on page 7. And the question that starts on line 14. I believe the Attorney General asked you a question earlier about whether or not you've or PNM has investigated the impossibility that you've claimed here. What I think may be missing from your answer at lines 16 to 18 is why it's difficult or impossible. So I was hoping that you could maybe give me some further clarification.
The list that Mr. Takahashi provides is fairly exhaustive, and I believe, and we believe, that it would take time and significant effort to address some of these. But again, if there are benefits that I am unaware of from the avoided costs as I receive it, there may be benefits on this list that are implicitly included that I am unaware of.
Could evaluating some of these benefits be a worthwhile effort in the future?
It certainly could. Again, I think that witness Phillips, he calculates these and he would have more insight into that question, I believe.
Thank you. So that on that same page, the next question starting at line 20, this one is about the ratepayer discount rate. You state that PNM, didn't use a discount or the ratepayer discount rate, but I'm wondering what would be the effect on PNM's application if it did use a ratepayer discount rate? And I guess what I'm getting at is, would all the numbers change throughout the application if we used a different rate?
I'm not certain if it would or not, sir. We use the discount rate that was approved in our most recent filings.
Thank you. Going to page 9, and the question starts on page 8, but your answer is lines 1 through 17 on page 9. And this question and answer is about federal incentives. I want clarification whether you're saying that federal incentive education is going to be incorporated into your budgets for marketing and customer outreach.
So it will be incorporated throughout our programs. So as far as that being a cost, yes, it would be. We would also include this information on our PNM website as well.
Thank you. I recall you answering Mr. Elliott that it would be on your website and through different programs. Does that, since this is sort of I don't know if I would consider it a new addition to the application, but would this change the budgets at all in your programs or in your marketing and outreach, including information on federal incentives?
No, I don't believe it would change it significantly, because it would be more about educating and training and those types of things, including survey questions to gauge awareness, those types of channels.
Thank you. Now let's move to page 14 and page 15. The last question on page 14 starts at line 17 and your answer continues to the next page. This one concerns the new pilot program in response to NMAG's witness's proposal. And it's correct that you state here that, you know, PNM is in discussions about implementing a new pilot program?
That is correct.
So my question is, how do these discussions come to fruition? Is this something that would be implemented in this plan or in your next triennial plan?
So we consistently speak with our implementers as to any ideas or recommendations that they have based on what they're doing in other markets. And so we modify our programs based on that to see if it works in our market. So these discussions happen on an ongoing basis. And if it fits within the program parameter, we will certainly try it. And that can happen at any time. It's just case by case basis.
Does that modification that you mentioned, is that something that has to be approved by the commission, or is that something that may alter the budget for the program?
No, we make sure that it is not a significant program change, that it is within the parameters of the program and the program budget and cost effectiveness.
Okay. Moving along again to page 16 of your rebuttal. The first Q&A on that page relates to Justice 40, the issue raised by NMAG witness Takahashi. And you state here that PNM will explore further this issue of Justice 40, but I'm wondering, what does explore further look like to you?
So we currently don't target those specific communities. We target low-income customers at or below 200% of poverty level. Those communities may naturally benefit from some of our programs, but this would entail a broader company discussion with some of our departments that work with our low-income customers to see if there are ways that we can identify those specific communities to target these programs.
Is PNM under any federal requirement to address Justice 40 communities?
Not as far as I know.
Thank you. Let's turn to page 17. And the first Q&A on that page, starting at line 2. This question is about heat pump incentives. You responded here that, you know, generally PNM will consider lowering the incentives on ACs and increasing them for heat pumps. Mm-hmm. And I understand that there's, you know, there are explicit dollar amounts associated with these incentives, but your answer doesn't include specifics. So I'm wondering if you're able to provide those numbers either now orally, or this could potentially be a bench request. But just wondering what the exact numbers for those incentives would be in response to all the testimony on heat pumps.
So we did provide our incentive list through Discovery. However, we will, and we do on an ongoing basis, increase incentives. So I don't specifically have a number at the top of my head of what that incentive would look like. We offer heat pumps in multiple programs, but we do on an ongoing basis increase those, and we are planning to continue to do that as we do when we evaluate the market.
Thank you. Mr. Verhul, could you please note my request for an explicit listing of the incentive structure for ACs and heat pumps?
Yes, sir.
And Mr. Hearing Examiner, I don't know how you want me to phrase that, but I don't know if that should be bench request number 1 or however.
Yes, it should.
Okay.
Bench request number 1 has just been issued by Hearing Examiner Lundin.
Thank you, sir. Ms. James, my final question for you relates to page 23 of your rebuttal and your answers at lines 3 through 5. So here you say that PNM will agree to increase base level savings from 49 gigawatt hours to 80 gigawatt hours for 2024 and 2025. So am I correct in thinking that whether the base level is 49 or 80, there's no substantive difference, because according to PNM's projections, you're going to max out the incentive cap under either scenario?
That is correct.
Okay. Thank you very much. I don't have any further questions.
Thank you, sir.
Thank you, Mr. Lundin. Mr. Verhul, do you have any redirect from Ms. James?
I do not. Thank you.
Okay. Ms. James, thank you very much for your testimony. You are excused. Appreciate
Thank
your
you, sir.
testimony, ma'am.
Thank you.
Okay. We're now at 10:26, since we started a little late. Could PNM please call its next witness?
We can.
If you have the witness available, otherwise we'll go ahead and take our mid-morning break at the usual time, or close to usual time of 10:30.
Yes, we've got to get Ms. James out of the room and Mr. Phillips in, but Mr. Phillips, if you're there at the PNM witness computer,
All
if
right.
you could.
Well, we ought to just go ahead and just take our 15-minute break and then come back, if that's okay.
Yes, sir.
So let's come back at 10:45. We're in recess until 10:45. Thank you. Have a good break.
Thank you.
Mr. Vihul,
Yes, sir.
would you please call PNM's next witness?
I will, Mr. Hearing Examiner. PNM calls Nicholas Phillips.
Mr. Phillips, would you raise your right hand, sir? Do you solemnly swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Good morning, Mr. Phillips. Please state your name and job title.
My name is Nicholas L. Phillips. I'm the Director of Integrated Resource Planning for Public Service Company of New Mexico.
Do you have before you what's been labeled PNM Exhibit 4?
Yes, I do.
What is that?
That is my pre-filed direct testimony that was filed in this proceeding.
Was it prepared by you or under your supervision?
Yes, sir, it was.
Is it a true and accurate account to the best of your knowledge?
Yes, sir, it is.
Are there any additions or corrections to it?
No, sir, there are not.
If I asked you the same questions today, would the answers be the same?
Yes, sir, they would.
Mr. Hearing Examiner, I move PNM Exhibit 4, the direct testimony of Nicholas Phillips, into evidence.
Is there any objection? Hearing none, PNM Exhibit 4 is admitted.
Mr. Phillips, do you have before you what's been labeled PNM Exhibit 5?
Yes, sir, I do.
What is that?
That is my pre-filed rebuttal testimony that was filed in this proceeding.
Was this prepared by you or under your supervision?
Yes, sir, it was.
Is it a true and accurate account to the best of your knowledge?
Yes, sir, it is.
Are there any additions or corrections to it?
No, sir, there are not.
If I asked you the same questions today, would the answers be the same?
Yes, sir, they would.
Mr. Hearing Examiner,
Question.
at this time, I'd like to move PNM Exhibit 5, the rebuttal testimony of Nicholas Phillips, into evidence.
Is there any objection? Hearing none, PNM Exhibit 5 is admitted.
I offer the witness for cross-examination.
Thank you, Mr. Vihul. Mr. Elliott, any questions for Mr. Phillips?
Yes, Mr. Hearing Examiner, think I have, well, I'd like to ask for 30 minutes. I hope that I won't use that time.
30 minutes requested, 30 minutes granted. Please proceed.
Thank you. Good morning. Good morning, Mr. Phillips.
Good morning, Mr. Elliott.
It's good to see you.
Good to see you as well.
I would like to ask you about the avoided cost study. This stemmed from case 20-00087. Is that right?
We performed a new avoided cost study as we prepared the filing for this docket. I guess maybe if you could clarify your question a bit more for me.
So I think it was mentioned in, I believe it was your testimony, that PNM was directed to conduct an avoided cost study in 20-00087, decretal paragraph I, if I'm not mistaken.
You're referring to the avoided transmission and distribution component as a part of the overall avoided cost study?
Is that right? Is that how it's how you understand it?
Yes, sir.
Okay. You said that you performed a new avoided cost study for this filing?
Yes, sir, that's correct. In the anticipation of our energy efficiency plan filing every 3 years, we perform a new avoided generation and capacity and generation energy avoided cost study as a part of the decretal paragraph in the previous energy efficiency plan case that you referenced. There was a request for PNM to perform as part of its avoided cost study an avoided transmission and distribution cost study as well.
Okay. So can you just direct me to where in the application the avoided cost study is located?
In the application itself, I am not sure. It'll take me a minute to comb through the application to find it. The application or the avoided cost study results were presented in my direct testimony as well as referenced in the energy efficiency plan itself, I believe.
Okay. So I just want to look at, because on page 2 of your rebuttal, line lines 15 through 17, you take issue with Mr. Takahashi's recommendation that PNM conduct a avoided cost study that uses a longer period of examination, right?
At pages 2, the lines you referenced, I do take issue with Mr. Takahashi characterizing PNMs as not having performed an avoided transmission and distribution cost study. Later in the testimony, I do respond to the specific criticism of the duration of that study.
Okay, and because through your testimony, I do see discussion and summary of the avoided cost study. I just didn't see the study itself. But let me just ask, so Mr. Takahashi recommended a 10-year look back, and PNM used 5 years. Is that right?
For the avoided transmission and distribution cost study that PNM conducted, PNM used a 5-year historical approach to analyzing historic avoided transmission and distribution costs.
Okay, so the reason that you prefer the 5 years, that you use the 5 years, is that you believe this is a more accurate historic look back?
Generally speaking, when analyzing avoided costs, we want to make sure that the application of those avoided costs are going to reflect what is actually avoidable during the period of time in which the alternative investments are being considered. And in doing so, we want to look at a reasonable amount of historic data. For the purposes of preparing the avoided cost study in this proceeding, I believe that 5 years was an appropriate length of time to examine the historic data.
So if we go through so I'm looking at page 8 of your direct testimony. Do you have that available?
Yes, sir, I do. I've got it in front of me.
Okay. So on lines 20 to 23, and you're going to explain to me the difference here. You say that PNM did not conduct a system planning study to analyze potential deferral or avoided values of transmission and distribution for 2024, and instead focused on the historic cost approach. So just explain to me the difference between the system planning study that did not use avoided values for T&D and the historic approach cost, because you say that in both instances there was no avoided investments. Is that right?
Perhaps there's a misunderstanding. The system planning approach and the historic cost approach are two generally accepted methodologies to explore what a potential transmission and distribution avoided cost would be. My testimony here describes that we use the historic cost approach, not the system planning approach, to perform that avoided cost study. So I cannot sit here today and make a claim that the system planning approach did not identify any avoided T&D cost. We did not perform that analysis.
Okay.
We performed a historic cost approach, and the historic cost analysis that we performed, subject to the methodology that I've laid out throughout the entire answer we're referring to. There's a number of steps that must be undergone to ensure that we're only looking at investments that would have been avoided directly as a result of energy efficiency. That historic cost approach did not identify any investments in the T&D system that PNM felt it would have avoided given increased levels of energy efficiency.
Okay. And so I just wanted to walk through that. I think you describe it starting at page 9. And so the first step is that PNM pulled capital expenditures functionalized into transmission and distribution investments. Is that right? So you just pulled all the data, and then you had the transmission and distribution departments review it to identify those projects. Is that right?
Generally, yes. With the note that we would need to go back to page 8 of my direct testimony, lines 1 through 11, that discuss specific types of costs that we would need to remove from the overall examination that would be unrelated to those that would be avoided due to energy efficiency.
Okay, and I see that there. And then you say that, and then at the end, lines 8 through 12, you're describing the findings of that review, right? And that's that you didn't, most of the investments in the last 5 years and those projected to be undertaken in the next are to replace aging infrastructure of new generation. So there were no applicable investments, right?
I'm sorry.
In the 5 years that you looked at.
That is correct. The analysis that PNM conducted did not identify any specific investments in the historic 5-year period that would have been avoided due to energy efficiency, nor does PNM believe there are any investments budgeted over the next 5 years that would be avoided due to energy efficiency. And that's one of the keys here. We want to make sure that the avoided costs that we're using are focused on what actually could be avoided, not what a theoretical avoided cost would be.
Okay. And just to confirm, you say most of the projects during this period, most of the investments in the last 5 years, right? Is that essentially all of them, or is it all of them?
Yes. So you're specifically referring to
line 8.
Line 8. Yes,
Yeah.
I did say most of the investments, and in fact, it was all the investments that our our transmission and distribution planning groups looked at. None of what they looked at was identified as being avoidable. I suppose there is the possibility that there's an investment that was overlooked, but everything that we examined after looking at it, we did not believe that it would have been avoidable due to energy efficiency.
Okay. Let me ask, do you know if there were projects that would have fallen into that category had you expanded it to 10 years?
We did not perform that analysis.
Okay. Moving on to line 16, line 14 of page 9. This is where you explain your last statement in more detail. And specifically, starting at line 16, you say, PNM has met with resistance in expanding its distribution system on overloaded feeders. As a result, PNM has generally been deferring investment and instead operating its system at or near equipment ratings. My question is, what sort of resistance are you encountering on expanding your distribution system on overloaded feeders?
Sure. The specific example that I was referring to here is the Paloma substation that was proposed as an expansion of the distribution system in the Northeast Heights area of Albuquerque. The feeders up in that area are operating at or near equipment rating levels, and it was identified in order to serve continuing load growth in that area, we would need to expand the distribution system. That expansion, and specifically the identification of a needed new substation at Palomas in that area, was met with resistance from homeowners and other community members in that area. And to date, that substation has still not been built.
Okay. Does PNM track investments that it would otherwise make, but for resistance of this nature?
No, sir. PNM only books or tracks investments that it has made.
Okay. That's for the investment purpose, but right, for accounting purposes.
Yes, sir. For booking purposes of investments, we would not book an investment that has not been made. We certainly do know what the expected investments, for example, at Palomas would have been, but those investments have not been made.
Okay. I was thinking maybe PNM had a list of other locations where it's contemplating investments, but for resistance from communities and I was wondering if PNM has anything such as that.
No, sir, not that I'm aware of.
Okay. So I wanted to move on to, I believe it's page 4 of your rebuttal. This is where starting at lines 4, but specifically line 8 through 10. The result of PNM's avoided transmission and distribution study was $0. So that's very low, right? That's a very low finding.
I mean, I would say that it is an accurate representation of the avoided cost PNM has experienced recently and what PNM reasonably expects it would be able to avoid in the near-term future.
Okay, so, but you're using a proxy price anyway, right?
PNM is recommending to continue to use a proxy cost for the time being. We do, as I stated in my testimony at that same question, recognize that in theory, energy efficiency can lead to avoided investments in the T&D systems. We want to keep the proxy in there as a placeholder. There will be a time in the future when those types of investments could be avoided. However, currently, we do not believe there are investments in the T&D system that would be avoided in the near term as a result of incremental energy efficiency. I would note that the proxy costs are a carryover from what was included in our 2020 energy efficiency plan when stakeholders asked us to consider whether we could, at that point in time, start to use an avoided T&D cost in our overall avoided cost study. And we did make an agreement to start doing that. And the historic cost approach that I've outlined here is consistent with some of the other utilities that we had discussed in the 2020 filing that led to the use of that proxy.
Okay. And the proxy price, can you tell me what that is?
I believe it was a $5 per kW year cost escalated at inflation.
Okay. And how does that generally compare to other utilities?
I only remember what we saw from other utilities when I looked at the proxy costs that we incorporated in 2020. And my recollection was that those utilities ranged from, a couple dollars up to maybe $10 or $12 per kW year. So we picked something in the middle. But I also would note that a survey of utility costs is not a adequate substitute for a specific analysis of PNM's costs.
Noted. Okay. So if you use a zero, I mean, not that you're using, but the implication of the avoided T&D cost study of $0, does that mean that energy efficiency measures that are installed today if they become cost effective, say after implementation of grid mod, and they have like a lifetime of 20 years, that perhaps that's not being captured?
I'm sorry, Mr. Elliott, I don't quite capture the question. If you could ask it again.
Well, so the avoided T&D study, right? That's a 5-year, it's a 5-year horizon.
The historic period was a 5-year examination of historic costs. The question would then be, how far forward would any estimate of avoided cost captured during those 5 years be valid? The program plan here is only looking for, avoided investments, or I should say alternative investments in energy efficiency over the next 3 years. And that's why PNM also looked at a forward-looking 5-year period to examine what it believes it could avoid in its budget. We will be making a new plan filing 3 years again from now, and we can certainly look at updating all of our avoided costs then. I don't know if T&D will lead to a substantially different result than they are today. A lot of what is being invested in grid mod. The meters, for example, would have no bearing whatsoever on energy efficiency avoided usage.
Okay. I was thinking, and Ms. Beatles had asked in her prior cross-examination, Ms. James, about grid-enabled heat pumps, for example. And I was thinking, okay, well, here's a technology that isn't currently enabled, but I could potentially purchase that sort of heat pump. And maybe within the next 5 years, it becomes cost effective or beneficial for energy efficiency purposes. And then over a 20-year lifespan, for example, it has a material impact. That wouldn't be captured in the current analysis. Is that right?
I would disagree with the underlying premise of the question, mainly because we justify alternative investments based on the best information we know at a point in time. And so if those energy efficiency programs are cost effective today, based on the avoided costs that are being compared to, we're not going to go 5 years from now and then play hindsight football and say, well, wait a second, is this still or is this not cost effective? It was cost effective on when we justified the programs. A second piece that I would note about the specific example is right now PNM is not a winter peaking system. So in order for heat pumps, for example, to lead to avoided T&D costs, there would have to get to a point where the non-coincident peak loads, if we're thinking about the distribution system in the winter, would have to exceed those in the summer and thus drive additional investments that could then be avoided. PNM system is not at that point.
Okay. And when you say PNM system isn't a winter peaking system, that just means that our peaks are in the summer because of it being hotter here in the summer than colder here in the winter, right?
The electric demands in the summer still exceed those in the winter. And so to the extent we build the system to meet those summer demands, we would not need to make incremental investments to meet those winter demands that then otherwise would be avoided by heat pumps.
But PNM, Mr. Elliott, PNM anticipates that demand changing over time, doesn't it?
Yes,
Mr.
sir.
Phillips?
Yes, sir, Mr. Medeiros, we do. As more and more homes switch to electric heating and other things, we do expect to be, a dual peaking system, and eventually it could be that the winter peak overtakes that. All of our projections, that's probably at least 15 years out.
Right. So by 2035, 2040, what you're omitting is, but I know you're not omitting on purpose, is the electrification of the vehicles that folks are going to be driving eventually as California drives this process, right? We're only going to have electric vehicles to purchase. So folks are going to have obviously an incentive in order to get to work and travel around to charge their vehicles, right? From home.
Yes, yes, sir. And our projections, as you just noted, if we look at electric vehicle adoption and building electrification, near the end of a 20-year planning period, there is a chance will we become an actual winter peaking utility, but certainly we will have too pronounced both a summer and a winter peak.
Thank you. Go ahead, Mr. Elliott.
Well, I think that I'm going to leave. Well, let me just ask this in the time I have left, Mr. Phillips. I wanted to ask you about the DR requirements from the final order in 20-00218.
Yes, sir.
So I believe you mentioned that the commission recognized the need for a holistic evaluation of PNM's DR needs. What is holistic evaluation mean?
There was no specific definition in the commission's order. We took holistic to mean to consider a ground up RFP as well as full examination of overall capacity needs and what proportion of those could cost effectively be met by DR. So we're looking at it both through the RFP that was issued and evaluated prior to filing this energy efficiency plan in accordance with the commission's order, as well as an ongoing assessment of potential new demand response that is considered through all source RFPs and other system evaluations.
But Mr. Phillips, I hate to go back there, but we're going to have to go back there today to 2020, 2021. Mr. Reynolds was the staff witness that talked about the holistic approach, right?
I believe that is correct.
And he said through the subsequent RFP, it should be based on all available utility demand resources. Once PNM's approved energy efficiency load management program plan for 2021 to 2023 had run its course, right?
Yes, sir, that's correct.
Okay, go ahead, Mr. Elliott.
Well, I was curious on page. Witness Takahashi, the Attorney General's witness here, mentioned, I believe on page 42, he summarizes it, the results of the 2020 Energy Efficiency and Demand Response Study, PNM commissioned AEG to do. Do you recall that?
I'm pulling up his testimony now. You said page 42?
Yes, sir. I think it's at line 10. He starts talking about it.
Okay, so I'm with you. You're referring to AEG's 2020 demand response and energy efficiency potential study.
Yes, yes. And that study found that there was potential for peak load reduction from new measures that PNM had not included in its proposed program. And I'm wondering, shouldn't this study be part of PNM's holistic evaluation of DR potential?
I think that the holistic evaluation comes down to an actual RFP and assessing what PNM could actually bring on and how the attributes of those resources that are available from the market could be worked into the system. There's a big difference between what is potential versus what is actual and cost effective.
Or theoretical.
Yep.
Okay. I have no further questions, Mr. Phillips. Thank you for your time this morning.
Thank you, Mr. Elliott.
Thank you, Mr. Elliott. Mr. DeSalen, do you have any questions for
No.
Mr. Phillips?
No questions. Thank you, Mr. Hearing Examiner.
You're welcome. Western Resource Advocates. Ms. Beatles.
No, thank you. No questions.
Thank you. Staff, Mr. Borman.
Thank you. Staff has no questions.
Thank you, Mr. Borman. Mr. Lundin.
Yes, Mr. Hearing Examiner, I have a couple questions, and good morning, Mr. Phillips.
Good morning, Mr. Lundin.
So I only had one prepared question for you. However, your colleague, Ms. James, had deferred one to you as well. So feel free to be long-winded in your response because I don't have much here. But I'll start with my prepared question. If you would look at page 4 of your rebuttal testimony, and this is the Q&A at lines 12 through 19. You had touched on this in your discussion with Mr. Elliott. But regarding the T&D values, I'd like if you could elaborate on this answer a little bit more, and specifically, how would customers receive back the value of avoided costs?
Yes, sir. Customers would receive back that value if the alternative investments, in this case, the energy efficiency programs, over the course of their useful life would actually allow PNM to avoid other investments in the system. So it's only to the extent that the hypothetical that is posited when considering these alternative investments versus the avoided cost becomes an actuality that we avoid those costs in the future. So, as we sit here today, we would be examining, using the best information available, do we believe that by making the investments here in energy efficiency or incentivizing those programs, will it allow us to avoid the costs that we would otherwise have to occur in the future?
So you call the avoided costs proposed by witness Takahashi as these theoretical values, and you compare that to the actual expected costs, but in essence, aren't both of them kind of theoretical?
They would say, yes, you're right, that they're theoretical in two distinct ways. If we were to go to Mr. Takahashi's testimony, for example, and we talked about, or I heard some discussion about table 5 in his testimony, listing a number of different types of costs that could be avoided. Some of those costs could be avoided by some utilities and not by other utilities. And so you first have a question of, are the costs that you're including as the potential avoided costs, are they theoretical, or are they the ones that the utility that you're examining could actually avoid? The second theoretical or hypothetical is then, do we actually avoid those in the future by making these investments? And so they're two kind of separate theoreticals. So we want to make sure that whatever we're including in the avoided cost is something that could actually be avoided. So that way we're not attributing value to an alternative investment that it could never achieve.
So you kind of view the argument of the NMPRC's witnesses almost like I don't know how to say this, but it's like a valueless kind of benefit or cost that if it can't be avoided, or if it's not even possible to be avoided, then there's no value to it and there's no reason to consider it.
Right. And so maybe a tangible example, one of the items that's included in Mr. Takahashi's testimony is avoided future environmental compliance cost. Given the Energy Transition Act, PNM is never going to invest in another coal plant, right? We just couldn't meet the overall regulatory requirements. So we would not want to prescribe, for example, an avoided environmental compliance cost associated with a coal plant, when that's never an option that we could avoid. And so that's kind of step one, is saying, what are the actual investments that we could avoid? And then when we compare those to the alternative investment, does it lead to a reasonable expectation that there is going to be this value here? There's always that further approach that you could say, well, if I did a counterfactual, could I actually show that these investments were avoided? But that's still a theoretical or counterfactual. We want to make the investment decisions based on the best information we have here today. We should do that being as close to perfect as we can on what could actually be avoided, not just a spectrum of what is theoretically avoidable.
Thank you for that clarification. So I'm going to turn to the question that was deferred to you by witness James. So if you have her rebuttal testimony handy, we're going to look at that real quick.
Okay, let me pull that up real quick. And you did say her rebuttal.
Yes, witness James rebuttal at pages 6 and 7.
Okay. At pages 6 and 7, I am here with you.
Okay, so starting on page 6, there's a bullet list of items from Mr. Takahashi's testimony that are benefits to be included in a UCT calculation. And in the following Q&A, witness James had answered that these items would be difficult or impossible to quantify. I had asked her why it's difficult or impossible, and she gave an answer, but also partially deferred to you. So I was hoping that maybe you could elaborate on why calculating some of these would be difficult or impossible.
Sure, and perhaps I can also shed some light on what's, as I heard Miss James state, what's implicitly included in our calculations, and then maybe what's not there and what is difficult to calculate or maybe not reasonably able to be calculated. So the way we do our avoided cost calculations is we use our system planning model. And part of that model, along with just putting in energy cost and capacity cost and a load forecast and all those things, we also put in all of our regulatory requirements, such as a renewable portfolio standard requirement. And so in a scenario where we look at a future that does not have certain energy efficiency reductions to the load, we have an incremental amount of renewable portfolio standard compliance that has to be met by that portfolio. Similarly, you could think about the same thing with how we're going to meet our carbon intensity requirements and some of those other things. So a lot of this is actually already implicitly included within the avoided generation capacity and energy numbers that we're talking about. So we calculate avoided energy costs, we calculate avoided generating capacity costs. We did an avoided T&D study. We look at line losses to gross up these values, since you don't have to deliver the energy for a load that's not there, you avoid the losses. We include the cost of the renewable portfolio standard compliance. And again, I don't think there's a lot of avoided environmental compliance costs just due to the state's policy vis-a-vis the Energy Transition Act. So the majority of this list is actually already included within the way we do our analysis. Now, if we were to think about wholesale price wholesale price suppression effects as an example, this would say, is there enough change in the load due to reducing load by energy efficiency to cause the entire market that we buy and sell from to see a change in the overall marginal price? And PNM is just not that big of an entity where we would expect to see much in the way of wholesale price suppression. I remember prior to coming to PNM, I looked at it for some larger loads over in MISO, and it takes hundreds, if not thousands, of megawatts to move an entire market, not 20 or 30 megawatts a year. So trying to identify and then reflect how that would roll through would be a very difficult task to do, and it'd be very speculative, because we'd trying to estimate then what would everybody else who's buying and selling from this market think if there was a little bit less load. The avoided credit and collection costs, this would come down to another one that's pretty difficult, because you're not necessarily changing your overall customer base. You still have the same customer demographics. Would the reduction in certain load and a reduction in the bill associated with that lead to an incremental ability for customers not to go into forbearance? And so I think, again, that's a a pretty tough question to answer because we're not talking about gaining or losing customers. We're talking about changing marginal amounts of consumption. And then in terms of reduced risk and increased reliability, the increased reliability, at least from a capacity basis, is one of those costs that's already built into the avoided capacity costs. Because we're saying, when we design our system to be reliable, we can design it to be reliable for less money. So the majority of these, I really do think are already implicitly captured. There's a couple in there that are not, but I think that they are very small value proposition and are very difficult to try to come up with a reasonable estimate to include.
I appreciate your detailed answer, and I don't have any further questions.
Thank you, Mr. Lundin. And Mr. Phillips, you just mentioned that you were looking at something before you came to PNM for MISO. Where were you working then?
I was with a consulting firm called Brubaker and Associates.
Right. And you were with Brubaker, and then you came to PNM, right?
Yes, sir. That's correct.
And you had actually testified either for PNM when you were a member of the Brubaker group, right?
I had testified opposing PNM in a number of dockets prior to joining PNM after leaving Brubaker.
After leaving Brubaker?
Yes, sir.
Where were you? Whom were you affiliated with then?
When I was testifying on behalf of Brubaker, the group that retained us was NMPRC's predecessor, NMIEC.
Okay. Now, you had an interesting discussion with Hearing Examiner Lundin about avoided costs of transmission and distribution, right?
Mm-hmm.
It just occurred to me that there is a form of energy efficiency related to transmission and distribution. Do you know where I'm going with this? Do you have any idea?
I'm wondering if you're going to go towards the 12 megawatts of distribution batteries, maybe, but no, I'm not.
No,
sure.
Actually, no. I'm surprised that I masked it that well. I'm talking about actually grid enhancing technologies. Are you familiar with that? With those technologies?
I'm familiar with the term generally. It depends on which technology you might want to dive into.
I don't want to dive into any particular technology at this point because it's novel to New Mexico. But here we go again, right? I'm talking about dynamic line ratings, advanced power flow controls, and topology optimization, right?
Yes, sir.
Has PNM evaluated? When we talk about energy efficiency and load management, the company is focused on customer-facing programs and measures, right?
Yes, sir.
So grid enhancing technologies, the investment in those technologies would not fit the energy efficiency paradigm, right?
Not in the traditional sense where the utility could provide incentives to end users to purchase those devices.
What could we do to incentivize the utility to invest in grid enhancing technologies?
That's a great question that I hadn't given a lot of consideration to prior to just now.
I will say, while you think about, evaluating the answer, this isn't a surprise. I raised this during the rate case, and you're going to hear me continue to push on this, like I've pushed on other issues over the years. So this isn't something new that I brought up. I don't know if that you heard about me ask about that, but I'm going to continue that. So the question is, what could incentivize PNM to invest in grid enhancing technologies?
And so I'll start with saying, I know that we are looking internally at things such as dynamic line ratings and other ways to manage the T&D system. And I'll probably I don't want to say face some backlash, but I don't know that there necessarily needs to be additional specific incentives other than knowing that there's certainty that as we go through these processes and install those, that we can get timely recovery of those investments.
Are you okay? So it's not a matter of disincentivizing, offering a remedy for a disincentive for grid enhancing technologies, is it?
I don't think so. I would need to think more and probably talk to some colleagues,
Right.
but I don't think it's the same in energy efficiency where we're quote unquote reducing billing units. I think that when we're trying to compare these different alternative investments, that there's not that same end use effect when we're talking about grid enhancing technologies and that we just discussed.
Right. And you're familiar with FERC Order 2023?
I would say I'm generally aware with it. Our transmission department is much more involved with that than I am.
And would you accept that order encourages utilities to look at grid enhancing technologies?
Yes, and it's specifically because of that order that I've talked with our transmission planners about how they're looking at dynamic line ratings and other technologies. I'm just not the most in tune with all the specifics.
Are you familiar with the utility industry reporter by the name of David Roberts?
And no, sir, I'm not.
His Volts, VOLTS podcast?
No, sir, I'm not.
How about Julia Selker, SELKER?
I wish I could say yes, but no, I don't know that one either.
She's of the WATT, WATT coalition.
Unfortunately, I'm not familiar with her work.
Well, I commend you to that podcast with Selker, who specializes in grid enhancing technologies. And her thesis, shared by Mr. Roberts, who is an esteemed reporter, is that utilities have significant disincentives to invest in grid enhancing technologies. So I'm doing this to continue the dialogue with you down the road in the next case, when I can come back and ask you whether there are disincentives, because the thesis is at least that to the extent that there are efficiencies, and we're talking about energy efficiency here. So that's why I think it's pertinent. There are efficiencies involved in installing grid enhancing technologies that would accrue less of a return on investment than would building poles and wires. Are you familiar with that debate at least?
I am familiar with that debate. For prudent utilities, we should be trying to maximize value to our customers. And so that's where my initial answer came from, that I don't know that there's necessarily a strong incentive needed. We should be doing everything we can to provide safe and reliable service to our customers at lowest reasonable cost.
In fact, there's a study by the Brattle Group. Are you familiar with the study by the Brattle Group on grid enhancing technologies that showed in Kansas and Oklahoma that implementing GETs could double renewable energy uptake on the grid, and the investments would pay for themselves in approximately 6 months?
I've heard some of that quoted. I have not read the report.
Okay, so you're pretty well versed in this area. I'm speaking to the right person in the company, as I guessed, right?
I'm not as well versed as our T&D planners, but I do know some. Yes, sir.
And who leads that group? I forget.
Lori Williams is our director of transmission and substation planning, and then Omni Warner is our director of distribution planning and grid modernization.
Is the place we can look for this in the next IRP or the current IRP process?
We had not done anything in this current IRP process related to grid enabling technologies. I would think that is more on the grid modernization side, but there has not been a lot of study in that for the current IRP.
And there's a current grid modernization docket open, correct, for P&M?
Yes, sir.
Okay, well, I will have Deputy Chief Hearing Examiner Ryan focus like a laser on grid enhancing technologies. I tried to prod him already, but he has a benefit cost analysis. We used to call them cost benefit analyses. in that proceeding. So we'll address it there among other places, but I appreciate your good humor in addressing that. But one thing about what we could talk about, though, that you did anticipate is a demand response and the situation there. And as you know, back in, wow, your lighting changed significantly.
If you'll humor, if you, there it goes. The lights in the room just went off.
It kind of went Halloween on us there for a second ahead of time. It was interesting though, the lighting. So could you back in October 2020, in the second phase of the San Juan replacement resources proceeding in 2182 UT, we recommended that the PNM's proposed demand response replacement resource be addressed in a separate docket. That docket was created, and we held a hearing in, I guess it was January 2021, that nobody wanted to hold except for myself, right?
I don't know if anybody besides yourself wanted to hold it, but we did hold the hearing then. Yes, sir.
Well, the parties were unanimous that a hearing wasn't required in that case. Isn't that right?
I believe so.
But the hearing examiner felt differently.
Yes, sir. That's correct.
And I had a long conversation with you in that case, right? During the hearing.
Yes, sir. You did.
And I issued 3 bench requests to PNM and 1 to CCAE.
Yes, sir. That's correct.
So apparently a hearing might have been required in that case.
Yes, sir.
Well, and then as you recall, I recommended that the commission reject the contract with Itron for a demand response program in that case, right?
Yes, sir.
And I recommended that PNM, I guess I wasn't as precise as I should have been, but I recommended that PNM, I thought what I was recommending is that PNM file as part of its 2024 to 2026 triennial plan a demand response program proposal as part of his energy efficiency plan in this case. Isn't that what I recommended?
I thought that the recommendation was that we should consider the 24 megawatts holistically as a part of this case. Maybe the disconnect is whether there was a specific requirement to include an incremental 24 megawatts of demand response as a part of this plan, regardless of what the outcome of the RFP was.
But it was on page 47 of the recommended decision in 20218 UT. That's 20-00218-UT. I wrote, and the commission assume that the commission approved the recommended decision without any amendment, which it did. And that was the final order was issued in this case. In that case, excuse me, the 218 docket on March 24, 2021. Page 47, paragraph 9, I say that the PNM's approved energy efficiency and load management program for 2021 through 2023 has completed its course. -for implementation consistent with the EUEA and EE rule effective January 1, 2024, right? For implementation means it should be part of the following plan, right? At least that's what I tried to impart. For implementation. That means for inclusion, right? And I'm smiling because I really am not going to press the company on this. I just want to find out why we are in the situation we are with this, where you're punting it apparently to the IRP, the DR plan.
Well, and maybe to be a bit careful there, there's no specific, as we would see it, requirement in the IRP to bring about that 24 megawatts. We would consider holistically whether there's cost-effective DR that should be considered as alternatives to supply side. I think the confusion on PNM.
No, I'm not, let me pause you there. I'm not suggesting that there's a requirement in the IRP. I'm suggesting that there was a requirement. And so you're skipping over a point. There was a requirement in 2218 that PNM propose a cost-effective DR plan as part of its next triennial energy efficiency plan, i.e. for 2024 through 2026. Wasn't there a requirement that the commission issued?
And I think that's where PNM probably has gotten confused. The PNM's understanding was that the requirement for the 2024 to 2026 plan was to conduct a holistic RFP, and to the extent that there was cost-effective DR, bring that forward that could fit into the plan. I think that what Ms. James had brought forward is the balance of as much energy efficiency as well as some demand response that we could do subject to the budgetary constraints of the EUEA.
But for implementation effective January 1, 2024, doesn't make sense just to conduct another RFP that you can then punt to the IRP process for evaluation without any strings attached. I thought there were strings attached here. To conduct the RFP with sufficient lead time, which I thought the evidence in the case indicated there was, according to Mr. Reynolds, and I don't think you thought anything differently at the time. And again, I'm not taking you to task on this. I'm just trying to find out where there's a misunderstanding, because frankly, when I opened your 2024 to 2026 energy efficiency plan, guess what the first thing I looked for was? The one thing that's missing, at least as far as I was concerned. So why is that?
And I do apologize, Mr. Hearing Examiner. I think, again, the issue is that PNM read the order and interpreted it to be that the requirement was to conduct the RFP and bring forward what was cost effective as part of this plan, not an absolute requirement of the incremental 24 megawatts. If there is still the desire to have that requirement brought forward, I think that that's something PNM is capable of doing with the clarifications that you're explaining to us, that this was not an RFP requirement, but a implementation requirement.
A proposal requirement.
Yes, sir.
Well, from the, let's go back a little bit then. From the company's perspective, in terms of, reliability on the system, isn't a demand response program for large customers something that might be important? At peak?
Yes, if the large customers were willing to participate, as well as we weren't going to be cannibalizing from the existing peak saver program. We do believe that demand response, is one of the primary pillars of what's going to allow us to decarbonize. But it is coming down to what the actual program constituents will sign up for.
Well, you had a program that was rejected back in 2021. I would have expected the company, I did expect the company to come back with a program in 2023 for implementation in 2024, but that didn't happen. I'm noting that for the record because this may require briefing, because I'm a little troubled that the company read that language and decided to parse it in a way that made it seem as if it was a no strings attached requirement. It was a toothless requirement. Because, well, it'll be interesting to see. We'll consider whether we need briefing on an explanation of why beyond what's in the testimony. But as far as what's in the testimony, that being yours, and I'm trying to make it so that Mr. Nagel doesn't have to come back later today or tomorrow. What's your best explanation for why there isn't a proposal for a demand response program that would not cannibalize the Peak Saver? Is it Peak Saver?
That's the commercial industrial program. Yes, sir.
Right. Okay. What's your best explanation for why there wasn't an additional proposal consistent with what was recommended by me in case number 2218-UT?
I think there's a couple of things. One would be just the review of the overall programs. It was felt it was better to extend the existing programs and keep those moving forward. The second piece of it is the budgetary and other requirements under the EUEA and the plan itself. The demand response is not a primary driver of energy savings. And so when we think about how to get a cost-effective portfolio of energy efficiency and demand response resources, adding more demand response certainly can add more cost, but it does not add much in the way of energy savings. And so more demand response usually leads to lower UCT values.
Okay, so that's an interesting point because this has been part of, we've talked about demand response programs being part of like an interruptible rate, right? In the rate case. So is it in the rate case? Is it part of the IRP? Is it in an energy efficiency plan case? And so going back to my discussions back in 2015 or 2016 with Mr. Ortiz about this, the idea was that, well, maybe it's not, the best place to propose a program like that may not be an energy efficiency proceeding, right? Is that what you're suggesting?
Yes, sir. The demand response products are more related to the capacity value that they provide to the system than the energy value. And so trying to weigh and balance those in a portfolio of energy efficiency resources can lead to counterintuitive results. It might be better to establish, if we want to have specific interruptible rate or demand response targets, to do those outside of the energy efficiency plan in order to make sure that we're not going to reduce the overall cost effectiveness given how we measure it for the energy efficiency portfolio.
Did the company evaluate what a demand response program, an additional one, might do, the impact it might have on the UCT?
I am not sure. I would have to ask Ms. James.
That's a second bench request because we don't have Ms. James to come back to. The second bench request is, did the company evaluate the impact of a new additional demand response program that was not proposed in this case? What impact it might have on the utility cost test, the UCT? And please, company, make your evaluation of that if possible, if it was done. If not, the answer is no. But based on what I hear from Mr. Phillips, it possibly may have been evaluated. And if so, please make that, please provide as much granular detail as you have on such a study if one was conducted, or analysis, if not a study.
Yes, sir.
Thank you. So let's talk about avoided costs very quickly, because we have a public commenter who would like to make public comment, and I'm holding her up. The cost of carbon is evaluated in your testimony, and I had it on screen and I lost it. Where do you do that analysis of avoided cost of carbon? You actually have a table, and like I said, I had that on screen, but I started switching around, Mr. Phillips, and I'm sorry, I lost that page.
You might be referring to PNM table NLP3, which shows some of the inputs to the overall avoided cost analysis.
Go ahead. You go ahead.
When performing the avoided energy cost analysis, we do include the prices listed here for every short ton of carbon that is emitted from the generating fleet. So as we add more energy efficiency, it reduces the amount of other generation, including that cost of carbon. And so the avoided cost of carbon based on these prices is implicitly included within the overall avoided energy cost.
You know, SPS in its recent energy efficiency case refused to use a price for carbon. That was a disputed issue. And my research after the case indicated that Colorado, of all places, I say of all places because obviously SPS has a sister utility, a larger sister utility in Colorado. Colorado is now going to have a price for carbon, isn't it? Not just the Western and Northeastern states.
I know that Colorado was considering that. I was unaware if they had reached a determinative conclusion.
So what you start with the price for carbon emissions in 2028. Why do you start in 2028?
That was consistent with the overall carbon price forecast that was being put together as a part of our 2023 IRP set of inputs. And so we had three different carbon forecasts. The mid-range one didn't anticipate a federal, so this is a proxy for a federal carbon tax price. And so given where the legislature is, there was not an expectation that there would be a federal carbon tax price possibly promulgated by the US Congress for at least
not maybe in a different universe.
Correct.
Frankly, it's going to come from the states, isn't it?
That's what we've seen thus far. This price here was a proxy for what could be done federally.
But that's illusory.
Correct. I don't think that New Mexico will likely put a carbon price out there because we already have a policy that reduces carbon absolutely, even without that price.
So the forecasts are not informed by California's program or the Pacific states or the Northeast states, the Northeast New England group of states?
We do work and include some of that information. The mid-range pricing that we're using here was specifically looking at federal policies. Our high pricing scenario looked more at the individual states as they were more aggressive than what the federal outlook looked like.
Where would that federal, it's not going to come through legislation. And it's kind of like a perfect, if it's not going to come through legislation, it's going to come from EPA or another, or FERC. And then what's going to happen to that? It's going to run into a buzzsaw at the Supreme Court. If it, with the eradication potentially very quickly here of the Chevron doctrine, right? So how did you come up with parameters for federal pricing of carbon emissions?
These particular prices, so maybe taking a step back, in developing these prices, some simulations were run by one of our consultants that looked at a national carbon policy and what would the prices need to be in order to reduce carbon emissions nationally by a certain amount relative to 2005 levels, very similar to what we always were thinking about in terms of the Paris Accord or the Clean Power Plan. And so these are the prices that were backed into that would reflect a hypothetical federal carbon tax necessary to reduce US emissions by an amount, I believe it was 80% or 75% relative to 2005 levels.
Okay. I appreciate the effort. I'm trying to understand how, since it's not going to happen by 2028 or even 2023 or potentially, we'll see. It would require a sea change at the federal level to actually get a price, right?
It would. I would also note that as we go further out in time, due to the effects of the Energy Transition Act in general and the overall level of carbon reductions on PNM system, even though the prices start to increase later in the forecast, there's so little carbon left on the system that the impacts and the overall avoided cost are small.
Fair enough. Thank you, Mr. Phillips. Mr. Vihul, any redirect? Or Mr. Lundin, do you have any further questions for Mr. Phillips first before any possible redirect?
No, Mr. Hearing Examiner, I do not.
Okay, thank you. Mr. Vihil?
Yes, thank you, Mr. Hearing Examiner. Very briefly, I wanted to go back to some of the questioning. I think it was primarily from the Attorney General's office with respect to avoided transmission and distribution costs. Mr. Phillips, I know you are not the Director of Transmission Planning or the Director of Distribution Planning. Can you tell us in general, though, what is driving? Well, I'm sorry, I'll back up a second. You've testified that PNM has deferred some of its distribution investments and rather has chosen to run some of its distribution components close to capacity in order to avoid having to make those investments. Am I characterizing that correctly?
Yes, sir.
Okay. Can you tell us at present and in the near future, are you aware of what's actually driving the need for upgrades to our distribution system?
Along with what's contemplated in the grid mod filing, the major components that are needing to be updated are aging infrastructure, as well as bringing previous investments and equipment into alignment with current standards. That's the primary driver investments on PNM's T&D system right now outside of grid mod.
Okay. You said that our load has remained relatively flat or declining. Is that right?
Yeah, so our load generally has been declining since roughly 2013 through present, except for the addition of a couple of specific large customers. Taking those couple of large customer additions out of the mix, the overall load has been declining for some time.
Okay. Are smaller, and when I say smaller, I mean rooftop up through maybe 5 megawatt solar facilities that interconnect to our distribution system. Are those driving the need for additional investments in distribution infrastructure?
They are certainly one of the reasons why the load that PNM is seeing at the meter has been decreasing over time. And depending on the concentration of those behind the meter installations, can cause the need for incremental investments on the distribution system, both from voltage consideration standpoints or the need to, or ability, I should say, to interconnect additional behind the meter solar and generation devices. Yes.
Are the upgrade requirements that those drive, are those potentially of a magnitude greater than could be obtained via load reductions achieved via energy efficiency?
Making sure I understand your question, are there investments that would be caused by the need for additional capabilities on the distribution system related to behind the meter generation that could be offset by energy efficiency or other investments? Is that?
No, my question was simply, PNM is going to have to make investments in its distribution system to accommodate the level of solar saturation in its service area, is my understanding. And you're nodding your head, so I assume I'm getting that right.
Yes, sir.
Yeah. And I'm curious if the types of investments that solar saturation is driving, are those of a magnitude greater than could be reduced via any energy efficiency program?
I would say it depends on the specific feeders. If an entire feeder is no longer capable of adding incremental rooftop solar, the investments necessary to support modifying or freeing up that hosting capacity would likely be greater than the investments that would be avoided from incremental energy efficiency.
Okay, thank you. I have no further questions. Thank you, Mr. Hearing Examiner.
Thank you, Mr. Vigil. Mr. Phillips, I wanted to convey to you that I hope you didn't view any of my questioning as a criticism of you, because it's not at all. I always value our conversations. I learn a lot from you in our discussions during hearings, and your command of the details is both welcome and impressive. So in case we have to call you back for anything, would you be available to be called back today at all? Today? I know you're not available tomorrow.
I'm available the rest of the day today if something else is needed.
Okay. You are excused provisionally, sir. Thank you very much for your testimony.
Thank you, sir. And I appreciate your compliments. And I've never taken offense to anything that we've interacted about this hearing or others.
Thank you, sir. Great. Now we have Mr. Nagel's rebuttal testimony. Mr. Lundin, would you have any questions for Mr. Nagel at this point, given my colloquy with Mr. Phillips?
Mr. Hearing Examiner, I do not have any questions.
Okay. We will entertain the excusal of Mr. Nagel from testifying and the stipulated admission of his testimony, if that's the company's pleasure, Mr. Vigil.
That would be the company's pleasure, Mr. Medeiros. Would you like me to make a motion at this time?
Yes, please.
I can do two, or I can do it in one. Do you have a preference?
Do it in one. That'd be fine. Thank you.
All right. Mr. Medeiros, at this time, I would move for the excusal of Roger Nagel as a witness and for the admission of PNM Exhibit 7, the rebuttal testimony of Roger Nagel.
Is there any objection to PNM's motion? Hearing none, Mr. Nagel is excused from testifying at this hearing, and PNM Exhibit 7 is admitted.
Thank you, sir.
Thank you. Okay, now we have a special guest. We have public comment, hopefully from someone who's been waiting very patiently this morning to provide public comment. Let's see if Ms. Beran is here. Ms. Beran, are you there?
Can you hear me?
Yes, ma'am.
Yes,
Do you have a camera, or would you prefer not to?
I prefer not to.
Here, that's fine. I apologize for the mix-up with the Zoom in the Zoom meetings this morning. We had a box checked that didn't allow PNM to actually participate in the hearing, believe it or not, because of the company's security parameters, so I had to issue a second invitation, and I apologize for you having to wait so long to provide public comment. But please go ahead and identify yourself if you're representing any organization and where you reside, and provide your public comment, Ms. Brown. You
Thank
have 3 minutes.
All right. My name is Sheila Betaon. I reside in the city of Albuquerque, New Mexico, and have been a PNM customer for well over 40 years. And I first just want to say thank you. I've been listening to you and the PNM gentleman. Thank you for those questions. Those were very good questions. I want to just ask if anyone from PNM here is listening, when you send out these bills for us to join Zoom, is there any way you could put them more clear in layman's terms for us as PNM paying customers? I don't understand a lot of the lingo that's in these, so I just kind of want to speak into what I think this is about energy efficient. Would that be correct? Okay. I am against, let me just rephrase that. I am completely for carbon. I am completely for fossil fuel. I am against solar panels, energy efficiency, and wind solars. I am against these wind solars for many reasons, but the biggest ones being I've talked to my friends across the United States. They bring more damage than good. The cost is crazy for one. They kill many of our birds. And I know this may just sound like a simpleton to a lot of you that may be online here, but I have been staying abreast and on top of what these wind solars are doing, especially in our oceans. So I'm completely against them. And I want to stay with carbon. I want to stay with fossil fuel. I don't buy into all of the hype that's going on across our country with all of this climate issue. And hearing you, Mr. Madero, speaking into this energy efficiency, yes, I wish PNM would have been able to have given you more answers than they did, and hoping they will next time. But I think as much money as I have put into PNM, I have a voice and I have every right to speak and give my opinion. It may not mean much to you all corporate at PNM, but I'm just letting you know what we pay for one wind solar to be carted in, put in place, et cetera, is I don't even want to get into the cost. And then the solar panels, I keep on top of how much money people have paid these solar companies only for them to up and leave town. So all of this is, I'm just asking if you could really put these bills in layman's terms for us people who are paying your salary. Thank you for your time.
Ms. Brown, thank you so much for your public comment. We truly value it. I believe the company values it as well.
Thank you.
But I'd like to point out that developing those notices is an ongoing iterative process to make them more reader friendly. And so the responsibility is on us hearing examiners along with the commission to make them more understandable. And we take that very seriously. And we've made revisions to the notice as we've gone along, and we'll continue to try and improve it. We'll also try and continue to improve where PNM places notices of these cases. PNM has made, based on my urging, they have made improvements about where you can actually find information about the cases over time. And I'd like to ask before you leave, because your concerns seem to be directed not so much about energy savings that the company is trying to encourage, but expenditures on renewable energy generation. Okay. So, Mr. Vigil, PNM's renewable energy plan case is what docket is that?
believe
It's
that's 23.
23196, right?
Yes, sir.
And when is the hearing in that case?
We held that hearing.
Oh, you did?
We did. It's available on
Okay.
YouTube, on the PRC website.
And folks, the window for providing public comment in that docket, written comment, is still open, isn't it?
Believe so.
I defer.
Mr.
I defer to
Okay.
Mr. Gorman.
I believe that the policy is that until the commission issues a final order in the case, parties or individuals who are not parties to the case can provide public comment in dockets like that. So Ms. Bedown, since the hearing has already taken place in that case, in case number 23-00196-UT, you may still provide a written comment and review the documents in that case.
Can you read the case
Online.
number one more time, Mr. Maderos?
Yes, ma'am. It's
I'm ready.
23-00196-UT.
All right, thank you.
You should be able to find information about that case. I haven't checked, but it should be online on PNM's website. And you can also find information about it in the commission's e-docket. And if you look at, so you should be, if you look at the notice in this case, you should be able to find where you can find e-docket online. So the window is still, should still be open for you to provide public comment for written comments in that case.
Okay, and to the PNM people there, I just want to say I made over 15 calls trying to get information in layman's terms of what this particular bill was about, and only to be hung up on and transferred 15 times. So I would appreciate it if you could inform your people when you call 246-5700 to know who to transfer me to. Thank you.
And Ms. Bedon, that's something that we've heard through the grapevine as well, that it's hard to find someone because they end up being folks like you end up trying to contact the commission. And so I've heard through, for instance, division director meetings that there are complaints like that from other consumers, that it's hard to find someone at PNM to explain the case to, and they're supposed to do that. And through this communication, I'm urging PNM to step up its game in that regard as well.
Thank you so much.
Thank you, Ms. Bedon. All right, so we are now at 12:13. And Ms. Bedon, thank you very much for your public comment. It's greatly appreciated.
You're very welcome.
Thank you. Okay, let's go ahead and take our lunch break now, if that works for the parties. And Ms. Ash-Hoyman, we'll be in recess until 1:15 p.m. Have a good lunch, all.
Thank you.
Thank you. We're in recess. Good afternoon, all. We're back from our lunch break in the hearing in case number 23-00138-UT. Mr. V. Hill, I hope you had a pleasant lunch. Are you ready to present PNM's next witness?
Yes, sir. Thank you. PNM calls Abraham Casas.
Mr. Casas, would you raise your right hand, sir? Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Mr. Casas, do you have before you what's been labeled PNM Exhibit 6?
Yes, I do.
What is that?
That is my direct testimony in this case.
Okay. And I'm sorry, I skipped a question. Would you please state your name and job title?
Yes, my first name is Abraham, last name Casas, that's C-A-S-A-S, and I'm a senior pricing analyst here at PNM Resources.
Okay. And we were talking about PNM Exhibit 6, your direct testimony. Was this prepared by you or under your supervision?
Yes, it was.
Is it a true and accurate account to the best of your knowledge?
Yes, it is.
Are there any additions or corrections to it today?
Beyond the notice of errata that PNM filed, there are some corrections that need to be made on PNM Exhibit AC5. So on PNM Exhibit AC5, page 1 of 1, the title that reads Calculation of PNM's Proposed 2021 should be crossed out and replaced with 2024. 2022 crossed out, replaced with 2025, and 2023 crossed out, replaced with 2026.
Okay, thank you. Any other corrections at this time beyond that and beyond the notice of errata?
So these corrections that I just mentioned, those will also be in the corrected PNM AC5. Those will also need to be made in that title.
Yes. Okay.
Where else, Mr. Casas?
In the notice of errata that PNM filed,
Yes.
PNM Exhibit AC5, the corrections that I just mentioned right now, that corrected AC5 will need to have those corrections made as well.
Understood. Just the ones that you mentioned, right? The change to the current
Correct.
triennial plan?
Yes.
Okay.
Okay, with respect to the Q&A in your direct testimony, if I asked you the same questions today, would the answers be the same?
Yes, they would.
Mr. Hearing Examiner, at this point, I'd like to move PNM Exhibit 6, the direct testimony of Abraham Casas, into testimony.
Into evidence.
I'm sorry, into evidence.
Right. Any objection? Hearing none. PNM Exhibit 6 is admitted. And Mr. Virgil, are you going to seek the admission of the errata as well?
I was just going to ask you if you would like me to do that. I'd be happy to through this witness.
Yes.
Okay. Mr. Casas, did PNM, do you have before you what's been labeled PNM Exhibit 8?
Yes, I do.
What is that?
That is PNM's notice of errata that was filed on, I believe, September 29th.
Okay. Can you describe at a high level what errors PNM discovered in its overall application that resulted in this notice of errata being filed?
Yeah, so the errors that PNM discovered, again, going back to PNM Exhibit AC5, the WACC that was being used in the calculation of the potential profit incentive was 10.73, and that has been corrected to be 8.82. And that correction then led to PNM witness James to have to make some changes in her direct testimony as well.
Okay, so the changes that this error being corrected flowed through into different people's testimony. That was all made, and you were part of the discussions and decision to make those corrections.
Correct.
Okay, and everything within that notice of errata, to the best of your knowledge, is correct. Is that right?
Yes, to the best of my knowledge, it is.
Okay. Mr. Hearing Examiner, at this point, I'd like to move PNM Exhibit 8, or notice of errata, into evidence.
PNM Exhibit 8, any objection? Hearing none, PNM Exhibit 8 is admitted. Let me show you what I just did before, because I may save the party some time and see if nobody objects to this. I'm going to put share screen what I did to PNM Exhibit AC5 corrected to see if there's any objection to it. Actually, well, let's see if this works. No, yeah, okay. I've got something going on here. It won't allow me to share the screen. Anyway, let's move on. I'll show you later. But I made as we were talking, I just went ahead and made the correction myself in legislative format. And I'll show you later. But right now, for some reason, it's not, I hit the wrong keys and I blocked myself for some reason. So we'll have to come back to it. But Mr. Hill, sorry for that interruption. Go ahead.
Not a problem. At this point, I offer the witness for cross-examination.
All right. Thank you, Mr. Freehill. Mr. Elliott?
No questions for this witness. Thank you.
Thank you, sir. Mr. DeSalen?
No questions here. Thank you, Mr. Hearing Examiner.
You're welcome. And Ms. Beatles, are you there? Western Resource Advocates? Ms. Beatles? Let's see if she's on the list here of participants. She may have checked out temporarily. Let's move
Yes,
forward.
I think that's probably the case.
Let's move forward with Mr. Lundin if he has any questions for Mr. Casas.
Mr. Hearing Examiner, I do not have any questions for this witness.
Okay. I don't either, which means unless there's Ms. Beatles, she's on. Ms. Beatles, do you have any questions for Mr. Casas?
No, I do not.
Okay, thank you. All right, Mr. Casas, it was great to see you again. You got off a lot easier in this case than you did back in September. So it's very good to see you. So let me see if I can pull up and see if this is what you represented before you left regarding that exhibit, if I can pull it up now, because I did something really screwy to that's a technical term of art I just said, to the PDFs. Let's see if I can find your 6 and show you what I did very quickly here and see if you agree with the change. Okay. Nope. Something really weird happened to share screen. Anyway, what I did was I interlineated in blue text. I changed proposed 2021, 2022, and 2023. I changed that with underlining, like you'll see in, red line form or legislative format, 2024, 2025, and 2026. Is that the correction?
Correct. Yes, it's the only correction was just changing the years
Okay.
to the proper.
If there's no objection, then I'll go ahead and substitute what I have, and you can all check to see if I did it okay, because I can't use share screen for some reason right now. There's no objection. I'll go ahead and substitute that P&M Exhibit 6 for the one that I just corrected on my own. Unless you already have that corrected, Mr. Hill.
We do not, so we would appreciate your having done the work for us.
Okay, great. Then I will do so without objection. Okay, Mr. Costas, thank you so much. You're excused.
Thank you.
Mr. Hearing Examiner, P&M has no further witnesses, but before we move on to other parties, I wanted to ask if this was an appropriate time to respond to your second bench request. I can verbally respond to you, and then you can, okay. So your second bench request had to do with whether or not P&M had evaluated the impact of 24 megawatts of demand response on the UCT calculation. And the short answer is no, we do not have any such study or any such calculation of that.
Okay. Consider bench request 2 therefore withdrawn.
Thank you.
You're welcome. Thank you for following up on that so quickly. So with P&M having presented its case in chief, correct, Mr. Verheul?
Yes, sir.
Let's move on then to the Attorney General's witness. Mr. Elliott?
Yes, Mr. Hearing Examiner, the Attorney General calls Kenji Takahashi.
Yes, yeah.
Mr. Takahashi, would you raise your right hand for me, sir? Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Good afternoon, Mr. Takahashi. How are you?
Very good. How are you?
Good. Mr. Takahashi, would you please identify yourself and your employer?
Yes. Yeah. My name is Kenji Takahashi. I'm principal associate at Synapse Energy Economics.
And Mr. Takahashi, do you have what has been labeled NMAG Exhibit 1 in front of you?
Yes, I do.
And would you please identify that?
Your testimony. Yeah, my own direct testimony.
Okay,
Yes.
thank you. And Mr. Takahashi, do you have any corrections to your testimony?
No, I don't.
Okay. And if I asked you the questions today that are in your testimony, would they be the same?
Yes, it will be the same.
Okay. Mr. Hearing Examiner, I would like to move into evidence NMAG Exhibit 1.
Mr. Takahashi, is your testimony in double space or is it less than double space type in Word?
Single space, I think. Yeah.
Okay, we ran into this issue in the P&M rate case with one of Western Resource Advocates witnesses, and their testimony in this case appears to be double spaced, but this one looks like it's slightly less than double spaced. Is there any objection to the admission of this exhibit, NMAG number 1? Okay, hearing none, it's admitted. However, in the future, if this isn't double spaced and it looks like it's slightly less than that, and I can't tell you why, because I wasn't provided the Word version of this document, but in the future, please, when you file testimony with the commission, and this goes for all the Attorney General's witnesses, please make sure that it's in double space in the future. That's all. Our rules require double spacing. So let's move on. In New Mexico, Attorney General Exhibit 1 is admitted. Questions for the witness, Mr. Takahashi. Mr. Verheul?
I have no questions.
Okay, thank you. Mr. DeSalen, CCAE.
No questions, Mr. Hearing Examiner. Thank you.
Ms. Beatles?
I have no questions as well. Thank you.
Thank you. Mr. Lundin?
Yes, Mr. Hearing Examiner, I have some questions. So good afternoon, Mr. Takahashi.
Good afternoon. Thank you.
So first, can you please turn to page 18 of your direct testimony?
Yes, on page 18. Yes.
And I'm looking at lines 14 through 18. This is a question about the UCT.
Yes.
Do you agree that the UCT is a simple pass-fail test?
I'm not sure what you mean by that. Could you elaborate on that?
Yes, so what I mean by that is there's only two results from a UCT test. Either it's below 1 and it fails the test, or it's above 1 and it passes the test. Would you agree with that?
Yeah, so I think it depends on the criteria you would use. Even in some cases, even if the result is less than 1, you may want to keep the program, certain program like low-income programs, for example, right? Because there might be some benefits that are not accounted for in the quantification of the benefits and costs.
Yes. And in your testimony, you're not alleging, or you're not making the argument that PNM's UCT values would fail the test if they were updated to account for all the additional benefits that you've cited. Is that right?
That is correct.
So I guess my overall question is, kind of at this stage in the procedural schedule, what benefit would there be for recalculating the UCT numbers if PNM has already shown that the plan passes the test?
Yeah, there might be benefits. I'm not. There might be benefits to for the next filing. If you do this exercise at this point, right, and you would find out more beneficial, cost-effective resources that are not part of this filing, right? That you have to flag that. Then for the next phase, the next filing, then you can take a deeper look at those programs. That's one way.
Yeah, accuracy helps in terms of measurement and verification for this triennial plan, and then to consistently apply that analysis that's more accurate to the following triennial plan 3 years out, correct?
Yes, and then it is important if there are certain benefits that are missing, it's really important to make a note about that within this proceeding so that you can take a deeper look into that in the next proceeding.
Thank you for your answer. I'm looking at page 30 now of your testimony.
Yes, on page 30, yes.
So this is the last Q&A as part of section 5 of your testimony regarding federal incentives. This is lines 1 through 4.
1 through 4. Yes.
You say that PNM should file an updated plan that fully accounts for the federal incentives.
Right.
So I'm wondering, would refiling the plan, would that entail having another fully litigated case on the plan?
So what I recommended is three sets of recommendations. One is the develop a robust marketing strategy and materials to educate IRA federal incentives. Okay. The second is to educate the trade allies, contractors, and so on about the programs, and then have a stakeholder meeting to discuss how you should modify the existing program designs and incentive amounts. But so the refiling, that's the last recommendation is after you go through this, right? After you have a stakeholder meeting, and based on the results of the discussion, then you make modifications to the filing, and that could be sort of mid-course modifications to the plan. Maybe because you probably need more time, for the modifications. So, and that's on page 33, from line 1 to 4. That's where I mentioned sort of the, timing of the refiling. Yeah.
But would that kind of necessitate us all getting back together like we're doing today and having another hearing and more testimony on a refiled plan?
That's a possibility, I would say.
Thank you. Let's move to page 34.
Yes, 34.
And I'm looking at lines 9 through 11.
9 through 11.
This is where you're citing the incentive levels offered by Xcel Energy in Colorado.
Right.
2,200 for the cold climate heat pumps, 1,700 for others. And then you recommend that PNM increase their incentive to $500. I'm wondering why your recommendation for PNM is so much lower than what you've cited for Xcel.
This is a bonus incentive. So in addition to what you would be offering to non-cold climate heat pumps. So I just took the delta difference between the incentive for a regular heat pump and then for a cold climate heat pump. The point is that I think it's important to give additional incentive bonus to cold climate heat pumps to send a signal that this is going to be very important technology in the climate of New Mexico.
But even if PNM were to accept your recommendation, wouldn't there still be a big delta between PNM's incentive and, let's say, Xcel's?
I'm not sure. Could you repeat that question?
Yeah. So the number I saw for the PNM's incentive for the heat pump is somewhere in the realm of $200 to $400. If you increase that by 500, we're still less than 1,000.
Right.
And then for Xcel, I'm seeing 2,200, which is significantly more. So I was just wondering why not go higher?
Yeah, good question. I guess, you would need, you want to do a more survey of what's the appropriate incentive for cold climate heat pumps, but it's possible to have a higher, it's maybe, effective to have a higher incentive, but I haven't given much, analysis of what would be the, optimal incentive for cold climate heat pumps.
This may also, this may be a question for Gideon as well, but in Discovery, did you ask PNM about maybe the budgetary impacts of increasing that incentive?
I don't think so. We didn't.
Okay.
Yeah, so that's another concern, right? Having a more incentive, then we would have a budgetary concern.
Thank you. Let's turn to page 35.
Yes.
And I'm looking at the question and answer from lines 3 to 14.
3 to 14.
And this question is in regards to the new pilot program that you have recommended PNM adopt.
Yes.
So how do you see such a program being developed and implemented? Is this something that you would like to see in this case, in the refiled version of this case, or in the future?
Yes, in this filing, yeah.
Okay.
This is recommendation, but yeah, in this filing.
In PNM witnesses James' rebuttal testimony, she said that PNM is currently discussing a new pilot program on this issue. Did that response satisfy the Attorney General's office?
So you're asking not me, but AG's office?
I mean, your opinion about what the AG's office would think about that, I suppose.
Well, so I haven't discussed this with the AG's office.
Okay. In your personal opinion, does PNM's response satisfy you as far as your recommendation?
Ms. James' response, you're talking about the manufacturer home pilot
Yes.
for low-income customers, right? So ideally, it would be great to have that in this filing, but there might be some issues that it is too early to have that in this filing. If so, would it be nice to have being developed and implemented during the course of the 3 years? 3 years filing. One.
From my understanding, from what PNM witness James told me, is that they're ongoing. They're developing their programs on an ongoing basis, and that these discussions they're having could, surface in this triennial plan as part of the program.
That sounds great.
Okay. Moving on, let's go to page 39 of your testimony.
39, yes.
And lines 3 through 8, this is related to the Justice 40 issue.
Right.
And you say there that the federal government has a goal that 40% of the benefits of energy efficiency programs flow to these communities.
Right.
And so your reference to energy efficiency programs, is that a reference to federal programs or to state programs? Or both?
So you're talking about the first sentence, line
Yes.
4 to 5?
Yes.
Yeah, so this is about federal government's program.
Okay.
Yeah, but my point is that you could align, PNM could align its own program with the federal government's programs, so that the PNM could receive, customers of the PNM could receive additional incentive, and then you would have more participations. Maybe the PNM would be able to reduce some incentives for some customers, and then use the freed up resources budgets to get more participations from other programs or other measures, right? So more participations if you have a support from federal government funding, right?
Is your recommendation for PNM to interrelate its programs with the federal programs?
Yes, that's my recommendation. Yeah.
Okay. In that case, that's all the questions I have, Mr. Takahashi. Thank you so much.
Great. Thanks so much for your questions.
Yes, great questions, Mr. Lunding. Thank you very much. Mr. Elliott, do you have any redirect?
No, thank you, Mr. Hearing Examiner.
Mr. Takahashi, we truly appreciate your testimony. And with that, your excuse, sir.
Great. Thank you for the opportunity.
Thank you. All right, let's move on to the next witness. Mr. DeSalen, would CCA please call its witness?
Yes, thank you. Coalition for Clean Affordable Energy calls Mr. Michael Kenny. And I think he should be on.
Let's see. Not yet. And I haven't had a request for admittance yet from him.
Okay. Okay.
There he is.
Very good.
Yeah, I discovered what the problem was with screen sharing. I'm on a new Mac and it blocks that feature. So at the break, although you can all check the Dropbox folder yourself to see what I did there with Mr. Casas' testimony. So we shouldn't need to do that. But at the break, so I can use screen share potentially, I'll log out and log back in so I can activate that feature, which was blocked by the Mac OS. All right. Mr. Kinney, good afternoon.
Good afternoon.
Good to see you again.
It's nice to see you.
Are you ready to be sworn again?
Yes,
Mr. Kenny, would you raise your right hand for me, sir? Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Kinney, good afternoon. State
Good
your
afternoon.
name, please. Spell it for the court reporter.
My name is Michael Kenny. It's spelled Michael. Kenny is Kenney.
And what is your position, Mr. Kenny?
I'm a senior program manager at the Southwest Energy Efficiency Project.
And what is your business address?
2334 North Broadway, Suite A, Boulder, Colorado, 80304.
And I'd like to refer you to the document that has been marked as CCAE Exhibit 1. Would you identify it, please?
That is my direct testimony in this case.
Okay, and did you prepare it?
Yes.
And are there any corrections that you need to make to it?
No.
And do you adopt that as your testimony today?
Yes, I do.
Okay, at this point, Mr. Hearing Examiner, before I move for its admission, I want to point out that the original Exhibit 1 that we filed and was also placed in the Dropbox, I noticed yesterday that there were a few exhibits that are responses, PNM's responses to interrogatories. Originally submitted those in a format that was basically rejected in a previous hearing. So we have gone back and reformatted those exhibits so that they are each the first page, the request or the interrogatory and the response information.
Yes.
Also, one or two pages that were out of order, and we fixed the order of some of the pages, but we've made no substantive changes to the document at all. And the corrected copy has been sent to you and to Hearing Examiner Lundeen and to the service list in this case. And I also downloaded it this morning onto the Dropbox. So what I'd like to do, if I could, is move for the admission of the corrected version of 1.
Yes, I'm pausing because I didn't realize that you also added it. I went ahead and took your email corrected copy and added it. So I see that there are 2 copies of the corrected CCA Exhibit 1. One at 8:32 a.m., which is yours, right? And then I did it again at 9:50. I'll delete the 9:50. But is there any objection to the the admission of corrected CCA Exhibit 1? Hearing none, CCA Exhibit 1 is admitted. I give you an example of how I know it's corrected. CCA Exhibit 11 to Mr. Kinney's testimony includes the cover page and the affirmation, self-affirmation page, as well as the meat of the response. So that is the correct copy of the file, Mr. DeSalen. So I went ahead and I don't know why I did that. I thought you'd only, anyway, I will delete that one additional extra copy of corrected Exhibit 1 right now, so there's no confusion, but thank you, sir.
Okay, well, thank you. I appreciate your sort of covering. It's better that there were 2 of them submitted than none of them. One thing I'd like to ask you, Mr. Hearing Examiner, is should I file corrected record center?
I'm sorry, you broke up there. The corrected what?
Yeah, my question is, should I file corrected exhibit with records, with RC records?
No, sir. I don't think
Okay,
that's
fine.
necessary. It'll be in the record admitted. Nobody's disputing that this is the same testimony. And
Right,
there
okay, thank you.
aren't any substantive changes. So that would have to be vetted before it could be admitted. If that were the case, we might have to have it filed, but we don't, because it's just the same testimony and the corrections are non-substantive. All right, so CCA Exhibit 1 is in, and you pass the witness, Mr. DeSalen?
Mr. Kenny is available for cross-examination. Thank you.
Thank you, sir. Mr. Vigil?
No questions.
All right, thank you, PNM. Let's see, next up would be Mr. Elliott, if he's available. Do you have any questions? No.
No, sir. Thank you.
Okay. And then I believe it would be, if I'm not missing anybody, it'd be Ms. Beatles, correct? Ms. Beatles, any questions?
No, thank you.
Okay. Well, Mr. Kinney, you are also getting off lighter than you did last month in the rate case, but we always appreciate your detailed testimony.
Mr. Hearing Examiner?
But we do have Mr. Lundin, and see, I'm rushing ahead. And Mr. Lundin, that's why we have a co-presiding hearing examiner. Mr. Lundin, do you have questions for Mr. Kinney?
I do, sir, but perhaps staff may have questions as well.
Right. So I'm really botching this here today and trying to rush. Mr. Borman, I'm so sorry. Do you have any questions for Mr. Kinney?
It's all good. Staff does not have any questions for Mr. Kinney.
Thank you. Thank you for your understanding. I do this every once in a while during a hearing where I'm trying to rush through, and it's not intentional. But Mr. Lundin, do you have questions?
Yeah, in that case, I'll proceed with my couple questions.
Thank you.
Good afternoon, Mr. Kinney.
Good afternoon.
So the first question I have for you is kind of a high level policy question, and I'll give you a little background first. I think it's fair to assume that you're familiar with New Mexico's Efficient Use of Energy Act.
Yes.
Yeah, so section 6217(5)(g) of that act requires the commission to perform a rulemaking no later than June 30th, 2025. And the commission shall adopt energy savings targets for electric utilities for 2026 and thereafter. So that being the basis, you reference PNM's energy efficiency savings targets for this triennial plan. And based on their targets, they would be maxing the energy efficiency cap immediately. So looking to the future, and given the commission's duty to pass a rulemaking for new targets, has the bar for energy efficiency savings been set too low by the New Mexico legislature thus far? being 5% of the 2020 sales?
I think given where we are today in 2023, it's maybe a little early to say whether or not the bar is too high or too low. I think we're seeing some utilities hit that bar. So far in that 5-year plan, we're seeing other utilities struggling to hit that. So I think it's going to be a little complicated to say whether or not, that 5%, averaging 1% per year is going to be too high or too low. I would say, if anything, what we're seeing so far is that the way the rules are framed is that it's not valuing demand response well. And I think we heard that earlier today within Mr. Phillips's testimony, that energy savings are the priority here. And as a result, we're not getting a ton of value from things like demand response, which provide a lot of capacity and avoided capacity value, not necessarily energy savings.
So if PNM kind of overperforms its projections for 2024, it's possible that they could satisfy that 5% 2020 sales requirement a whole year early. Would you categorize PNM as an overachieving utility in that sense?
With the way the goals were structured for these 5 years, if they achieve what was meant to take 5 years, then 4, then yes, they would be overachieving.
Do you think that fact would perhaps justify a future rule that, treats PNM differently than EPE or SPS, that is, requiring maybe a higher target per utility?
Well, I think we saw with the initial goal setting process that SPS had to be treated differently given their unique customer class makeup. And so I think there is a precedent, of treating some utilities differently when you're going through this goal setting process. How PNM would ended up being treated differently if they were to, be treated differently, I couldn't say what that might look like.
Well, thank you for your opinions there. My next question, it's more specific and granular, but if you would turn to page 19 of your direct testimony. And this is at lines 5 through 12. This is where you're talking about cost effectiveness and use of the weighted average cost of capital versus a ratepayer discount rate.
Mm-hmm.
So I'm wondering, what would be the effect or the impact on PNM's application if you were to use a ratepayer discount rate? And that is, would their numbers across the board all immediately change, or what would that impact be?
Yeah, holding all else equal, if you just changed the discount rate, and so right now PNM is using about a 7% discount rate, and there are multiple options if you're going to take a ratepayer discount rate approach. Taking the view of the customer, not of the utility, for that discount rate. And so, if you say, for example, did a 2.5% discount rate, you're going to see across the board the UCT values go up about 20%. And that's because every year from the first year you do a project, the efficiency savings matter more with a lower discount rate. So an air conditioner you install in 2025 or 2026 is going to still be delivering higher value in 2035 or 2036 with that lower discount rate.
So the lower discount rate would have a positive impact on the UCT number?
Yes.
So that is, it would make the programs look more cost effective?
Yes.
Okay. Thank you. That's all the questions I have.
Thank you, Mr. Lundin, and apologies again for skipping over several people. Ms. Freehold, do you have any redirect? Excuse me, not Mr. Borman. Do you have any redirect? Let me get refocused here. Not Mr. Borman, Mr. DeSalen.
think,
This is the right panel, right there. That one, Mr. DeSalen. Oi,
um,
do you have any redirect?
no, Mr. Herring. No, Mr. Herring Examiner, no redirect.
It helps to look at the right panel when you're speaking. I'm sorry for that. Okay, thank you,
No
Mr.
problem.
DeSalen. Mr. Kinney, now at this point, I prematurely thanked you for your testimony, but now I think is the proper time to thank you for your testimony and let you know that you're excused, sir.
Great. Thank you very much.
Thank you. Okay, now that we're hopefully back on track, Western Resource Advocates, Ms. Beatles, would you please call your witness?
Yes, thank you, Mr. Hearing Examiner. WRA calls Stacy Tellinghusen. Did I pronounce your name correctly, Stacy?
Yes. Would you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do. Thank you.
Thank you. Can you maybe turn your volume up just a tad?
Is that any better?
How about closer to the microphone? Let me hear you again.
Is that any better?
That's better. Thank you.
Okay.
Yes.
Thanks.
For the record, would you please state your name and your employer?
My name is Stacy Tellinghusen. I'm employed by Western Resource Advocates.
And what is your position with Western Resource Advocates?
My position is Deputy Director of Policy Development in the Clean Energy Program.
Do you have before you a copy of the direct testimony pre-filed in this matter on September 18th, 2023, that we have marked and uploaded as WRA Exhibit 1, your direct testimony?
I do.
And do you have any changes or corrections to that testimony?
I have one minor correction that I would like to make.
Stacy, the audio is going in and out. Is the court reporter hearing it the same way?
I am as well.
Is this any better?
Much better.
Okay,
Yes,
I'm sorry. I'm just trying to figure out which is the right microphone to use here.
that's it.
So, Ms. Beatles, I have one minor correction to make to my testimony.
Okay,
And
would you walk us through that, please?
Yes, on page 21 of my testimony, table 3, there's a table of, or the table has letters identifying each column, A, B, C, D, E, F, G, and then the last column is also labeled F, and it should be labeled H.
And
Yes.
is there a corresponding change in the caption for that table?
Yes, the last sentence of the caption says data in column F is calculated. It should say data in column H is calculated.
So, Mr. Hearing Examiner, Ms. Tellinghusen just alerted me to that yesterday, but as you can imagine, I was like caught up in trying to finish my rate case brief. And I just looked at it this morning and I said, yes, we do need, that's not just merely clerical. So I do need to submit to you or upload a version with that correction. And our legal assistant is also in the process of trying to get those briefs filed for the rate case. So she hasn't done that yet. How would you like me to proceed? I can do it today.
Well, we should have you file, or not file, excuse me, upload. If you can actually just send it to me and I'll do it, or to the parties.
Okay.
So that I can just go ahead and delete that. There's another change that needs to be made. You said that when you introduced Ms. Tellinghusen, that this is marked as WRA Exhibit 1. The version that it's in Dropbox is not marked WRA Exhibit 1. If you look, at the exhibit. If I'm not mistaken, if somebody wants to confirm that for me, it needs to be marked WR Exhibit 1. So you're going to have to upload a new version of it as well anyway.
And so if I upload that new version with that corrected, with a label marked as WRA Exhibit 1, and if I go ahead and make that correction, changing the column F references to H on page 21, should I just go ahead and upload that?
Just go ahead and upload it. But it might be duplicative of what you already have there. So I just have to remember to go in and delete the version that's not correct, or corrected. I would also label it in the file name for the PDF, corrected at the end, and also put on the cover page that it's WRA Exhibit 1 corrected.
Will do.
And then I have a question for the witness. That column, did you add it later? Did you have this table, Ms. Tellinghusen? Is it Tellinghusen? Okay, great. I didn't want to mispronounce. Did you add that column after you created the testimony, or how did that come about?
No, the column was in my original testimony filed September 18th. It just was mislabeled.
Okay. So with the corrected exhibit being along the lines that Ms. Tellinghusen narrated for us, and with the cover page indicating that it's WRA Exhibit 1 marked as such, corrected, is there any objection to the admission of WRA Exhibit 1? Hearing no objection, WRA 1 corrected is admitted.
Thank you. I now pass the witness for cross.
Thank you, Ms. Beatles. P&M, Mr. Verheul, any cross-examination?
I have no questions. Thank you.
Let's see, any questions from CCAE, Mr. DeSalen?
No questions. Thank you, Mr. Hearing Examiner.
And I skipped the Attorney General, but I remember just now. Mr. Elliott, any questions?
No, sir. Thank you.
You see what happens when I don't have that chart that I got used to in the rate case. It was easier to keep track. So apologies. And Mr. Borman.
Thank you, Mr. Hearing Examiner. I do not have any questions for Ms. Tellinghusen.
Okay. Mr. Lundin.
Mr. Hearing Examiner, I don't have any questions for this witness.
Okay, great. So there's no need for any redirect then. Ms. Tellinghusen, we appreciate your good testimony. It is now in the record, and you're lucky today you're excused as well.
Thank you.
Thank you, ma'am. Okay, let's move on then to, if we can, to staff's witnesses, if I'm not mistaken. Mr. Borman?
Thank you. Mr. Friedman is going to introduce Mr. Tupler.
Great. Okay. Is Mr. Friedman on? Yes, he is. Hey, Mr. Friedman.
Hello, Mr. Hearing Examiner. Yes, I will call up Mark Tupler.
I'm here.
Mr.
Mark,
Tupler.
can you, for the hearing examiner and the court reporter, can you state your name for the record?
May I swear him?
Oh, yes.
Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Good afternoon, Mr. Tupler. Can you state your name for the record?
Yes, sir. My name is Mark Tupler.
And what's your position with the PRC?
I am a senior economist with the NMPRC Utility Division.
And do you have a copy of your direct testimony that you filed in this case? It's known today as Staff's Exhibit 1.
Yes, I do.
And can you take a moment just to look through it briefly and make sure it's complete and accurate?
Yes, it appears to be.
Now, do you have any corrections that you would need to make to your direct testimony today?
I have none.
And if you were asked today at this hearing the same questions in your direct testimony, would your answers to those questions be the same, or would they have
Yes, sir,
changed?
Yes, sir, they would be.
Mr. Hearing Examiner, I moved for the admission of Mark Tupler's direct testimony.
Is there any objection to the admission of Staff Exhibit 1? Hearing none, Staff Exhibit 1 is admitted.
And I will pass the witness.
Thank you, Mr. Friedman. Mr. Verheul for P&M. Any questions for Mr. Tupler?
No questions. Thank you, Mr. Hearing Examiner.
Mr. DeSalen?
No questions, Mr. Hearing Examiner. Thank you.
I skipped the Attorney General again. I'm sorry, Mr. Elliott.
Okay.
Mr. Elliott, any questions?
No, sir. Thank you very much.
And Ms. Beatles for WRA. Any questions?
You're muted.
Yeah, no,
I am?
no, I
Ms.
was.
Beatles.
Oh, okay,
No, thank you.
okay. And then let's see, Mr. Lundin.
Mr. Hearing Examiner, I don't have any questions for this witness.
Okay, great. Thank you, Mr. Lundin. So I don't either, Mr. Tupler, so I appreciate your good testimony in this case, as
Yes.
your testimony in all cases are good, but in this case as well. So with that, sir, you're excused.
Thank you, sir.
Thank you. Staff, next witness, last witness.
Thank you. At this time, staff calls Agatha Malik.
Good afternoon.
Could the witness be sworn, please?
Ms. Malik, would you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Good afternoon, Ms. Malik, and welcome to testifying before the New Mexico PRC.
Thank you.
By whom are you employed and in what capacity?
I'm employed as a member of the utility division staff with the New Mexico Public Regulation Commission. My position is as an economist.
As part of your duties in that position, did you review the energy efficiency application submitted by PNM along with the testimony filed in this case?
Yes.
And based upon that review, did you prepare or participate in preparing testimony regarding that application?
Yes.
You should have before you a document marked as Staff Exhibit 2. Do you have that?
Yes, I do.
Can you identify that document?
Yes, it's the my prepared direct testimony.
In this case?
Yes.
Okay. Was Staff Exhibit 2 prepared by you or under your supervision?
Yes.
Do you have any changes or corrections that you have made in Staff Exhibit 2?
Yes, there are two corrections which reflect the pre-tax weighted average cost of capital that was changed by PNM. That's on page 6, line 18 of my testimony, as well as page 7, line 5.
Okay, and let's go to the one on page 6, line 18. Can you just describe briefly that change?
Yes. Initially, when PNM submitted the application, they made reference to the pre-tax weighted average cost of capital as being 10.73%. I've now changed that to reflect the 8.82%.
Okay, and
which
that
was filed in the errata.
Okay, and that was in PNM's errata, correct?
That's correct.
Okay, and that's on, just to confirm here, that's on page 6, line 18 of your direct testimony.
That's correct.
Okay, and then on page 7, you have a correction on line 5. Is that correct?
Yes.
Could you describe that briefly?
Again, it's another reference to the sliding scale being capped, not at what PNM had initially submitted, the 10.73%, but the 8.82%.
So, okay, thank you. And is it fair to say that both of these corrections are simply reflecting the change made from PNM's errata?
Yes, that is correct.
And these changes do not change the recommendations that you make in your testimony?
Yes,
They do not.
they do not.
Okay,
That's correct.
thank you. Okay, let's see. I have my questions here. If I asked you today the same questions as are set forth in Staff Exhibit 2, would your answers be the same as you have just corrected them?
Yes,
And those answers are true and correct to the best of your knowledge?
yes, they are.
Right, do you adopt Staff Exhibit 2 as your sworn testimony in this matter?
I'm sorry, could you repeat that? I couldn't quite hear the question.
Absolutely. Do you adopt Staff Exhibit 2 as your sworn testimony in this matter?
Yes.
Thank you. At this time, I move admission of Staff Exhibit 2.
Is there any objection to the admission of Staff Exhibit 2 as corrected? Those corrections are reflected already in the Dropbox folder version.
That is correct.
Hearing no objection, Staff Exhibit 2 is admitted.
Thank you. Ms. Malik is available for cross-examination.
Thank you, Ms. Malik. Thank you, Mr. Borman. Any questions for Ms. Malik from PNM, Mr. Vehul?
No, thank you, Mr. Hearing Examiner.
Mr. Elliott for the Attorney General?
No, thank you, Mr. Hearing Examiner.
Thank you. CCAE, Mr. DeSalen?
No questions, thank you.
Ms. Beatles for WRA?
No questions, thank you.
Okay. How about Mr. Lundin?
Mr. Hearing Examiner, I have no questions for this witness.
Okay, thank you. Thank you, Mr. Lundin. Ms. Malik, could you please turn to page 7 of your testimony?
Yes.
Actually, turn to page 9, I'm sorry. What I want to ask you about is the increase in the rider. That the rider, you see there on line 8, you accurately report that the rider impacts on customer bills is 3.64% in 2021, 3.581 in 2022, and 3.396 in 2023, as approved in case number 20-00087-887-UT, excuse me. That's the first triennial plan that PNM filed, correct?
Yes. That's my understanding.
So the comparable numbers are actually 3.952% of customer bills in 2024, as opposed to 3.640% in 2021. 4.058% in 2023, as opposed to 3.581 in 2022. And then finally, 2026, comparing it to 2023, it's 4.19% versus 3.396%. Is that correct? Is that correct?
I'm so sorry,
I'm just lining up the numbers, the percentage increases based off what the customers experienced or are experiencing now in 2023.
Mm-hmm.
So those are the differences, right? The increases?
That's the numbers you've cited are different than the ones that I had in my testimony.
Okay, let's go through it again then. Year 2024, it's 3.9 2%. Lines 1 to 2. In your testimony on page 9.
I'm sorry, the 3.952%, yes.
Then compare that to line 8 for 2021. The comparable would have been 3.640%, correct?
Yes, yes, that's correct.
And then compare 2025, which is 4.058% on line 3 of your testimony on page 9, right?
Yes, that's correct.
To 3.581% in 2022. That's line 8, correct?
Yes, that's correct.
And then we're comparing 2026, line 5, page 9, 4.191% of customer bills versus what was approved in 2023 on line 9, page 9, 3.396%, correct?
Yes, that's correct.
Okay, I ran through the numbers a little too quickly. Forgive me for doing that. But those are the comparisons, the comparables, right?
Yes, that's correct.
Okay, why do you think the increases are reasonable? I see that you say the increases are reasonable, but why do you think that these increases are reasonable? I didn't see Mr. Tupler testify to that because he references your testimony.
I think it's a relatively small percentage increase per customer class. It does not seem to be outside of a just and reasonable increase, in my view.
Well, it would have to be driven by increases in planned spending, right? That
Right, which
that staff thinks is reasonable overall.
Yes, that's correct.
And a UCT that provides customers sufficient bang for the buck to be worth it, correct?
Yes.
In terms of savings.
Yes.
Okay. Thank you, Ms. Malik. Staff, any redirect?
Yeah, really briefly. Ms. Malik, I think did staff find P&M's spending on energy efficiency programs reasonable in this case?
Yes.
Okay. And if you look at the numbers that that the hearing examiner walked you through on page 9 of your testimony, those numbers all seem to be around the same place, don't they? Between 3 and just over 4%.
Yes, that's
Okay.
correct.
Thank you. Those are my questions.
Good redirect, Mr. Borman. Thank you. So that what I understand is that the increases in spending correlate to the increases on the impact on customer bills. Ms. Malik, is that correct?
Yes, that's correct. That's right.
Okay, great. Anything else from Ms. Malik?
Nothing from staff.
Okay, great. Ms. Malik, thank you very much for your testimony.
Thank you, Mr. Hearing Examiner.
Thank you. You're excused.
Staff has no further witnesses.
Okay. Let's so we've reached I believe, correct me if I'm wrong, we've reached the end of the evidentiary phase of the hearing. I'd like to take a 10-minute break and come back to address post-hearing briefing. We have one bench request we need to get a deadline for, and we also need to address a proposed recommended decision that we're going to require in this case, briefs on contested issues, and response briefs. So in those 10 minutes, I'd like the parties to, if that's enough time, to consider proposing deadlines for filing those those submissions. What I'd like to see as part of that is that PNM will circulate a proposed recommended decision to the other parties for their comments. And then after receiving those comments from the parties, file a proposed recommended decision. And then also file simultaneously with that, if possible, briefs in chief on contested issues. And then after that, the filing of any response briefs. So let's take a 10-minute brief, a brief break for 10 minutes, and we'll come back after those 10 minutes at about 2:37 to conclude the hearing. Thank you all. We're in recess.
Thank you. But before we go back on the record, I just wanted to thank you for asking Ms. Malik some questions. I didn't want her to escape without being asked any questions.
Mr. Medeiros, I think you're muted.
All right, I thought my headphones were working. It showed that they were working. Can you hear me now?
Yes.
Yes, sir.
Oh, geez. All right, can you hear me through the webcam? Okay. Apologies for that. We are back from our afternoon recess in this case, and as indicated before the break, we had entered the post-evidentiary phase of proceeding, and we're going to deal with post-hearing briefing matters. We'd like to see a proposed recommended decision, that is, the commission, Mr. Lundin and I. Yeah, I'd like hearing examiner Lundin to address a specific issue that we feel may need briefing on. Hearing examiner Lundin, would you like to elaborate on that?
Yes, Mr. Hearing Examiner. So, it was raised throughout the AG's testimony about the recommendation for PNM to refile its energy efficiency plan. So personally, I would like briefing on that issue of whether or not that's feasible or prudent or appropriate at this stage in the proceeding.
Or required.
Yeah, or required. Just any legal issue that surrounds that. The issue of refiling their plan, I think, is fair game.
You also heard the discussion regarding demand response and the PNM's omission of an additional proposal or new proposal in this case, based on its interpretation of the commission's decision in the case rejecting the ITRON demand response proposal as part of the San Juan replacement resources. And so the parties should also focus on that issue if they deem it appropriate. So I'd like to get the parties' feedback on what they believe appropriate deadlines would be. There will not be a requirement of a expedited transcript in this case. So with that, we'd like to see, first off, a proposed recommended decision. Is there any questions from the parties, Mr. Vihul, about the proposed recommended decision? It will be PNM's obligation to draft and circulate a proposed recommended decision for all the parties in the case. and then to file a proposed recommended decision. Are there any questions about that?
I presume by circulating to other parties, that would be for them to provide comment and feedback, and then for me to incorporate those comments and feedback into the proposed RD?
Yes, if you can arrive at an agreement on those proposals. If not, then if some problem arises, which it has in the past, that should be indicated in the briefing. Because when you get to the proposed decision and you have a contested issue, you should note, I believe, in the proposed decision that this is the contested issue, and P&M addresses this issue in his brief in chief on pages or in section on pages, whatever that may be, blank to blank. And then the parties should also, in their briefs in chief, then address that contested issue.
Mr. Hearing Examiner?
Yes.
For me personally, and given my experience litigating these cases, I would prefer not to see any proposed conclusions on contested issues, just to avoid the issue of, litigation between the parties on figuring out what the proposed RD should look like.
Yeah, I agree with that. So just propose findings and conclusions that are uncontested, Mr. Vihul, and the parties also. And then they can address the contested findings and conclusions that they wish to be made in their briefs in chief and then response briefs. And of course, the response briefs could be a response not just to the brief in chief of the party with which they have an issue, but also with the proposed decision. You saw, I believe, City of Las Cruces do that in cases involving EPE, where they took issue with the proposed decision. And you might see that in the response brief. You might also see it in the brief in chief if something flares up that is a dispute over, something that wasn't able to be resolved in comments to the proposed decision that was filed. Well, so let's set deadlines for that. Do the parties have any proposals for filing the proposed recommended decision and briefs in chief? I will let you know that we've also seen it staggered where the proposed recommended decision is filed separately from the briefs in chief. SPS has done that on occasion as well. So we could have the PRD file first and then have the briefs in chief filed a week later, and then response briefs filed, which would then address only, essentially some confusion. Response briefs would only then be focused on the briefs in chief. I'll leave it up to the parties. It's been done different ways. Any
We're open to
proposals?
doing it however works for you and the other parties. I think we could be flexible in that regard.
How would you prefer to do it, Mr. Vihul?
I think I would prefer to file a proposed recommended decision and then stagger the brief in chief, just to keep those very separate so everyone's extremely clear on what the contested issues are.
Okay, that sounds good. So do you have a proposal for filing the proposed recommended decision first?
How late can I push it? I've already got a couple other briefs staring me in the face right now.
Sure. We're at the 18th. A month from now would be November 17th. Would that work?
Yeah, I think it would, Mr. Hearing Examiner. And with that, I would also like some feedback from the parties on when they would want me to circulate a draft for their comment and feedback.
I have a suggestion. If they could see a draft of the proposed recommended decision by the 10th, and then give them time during that week to propose comments, or do you think that the parties needed more time than that?
Plenty for me.
I think I'll need more time. I'm in a similar situation, I think, as Mr. Refuel. I've got several hearings and several briefs due in the next couple of months. And the hearings are going to be longer than this one.
Mr. Hearing Examiner, to be completely blunt, because I still have this Meta, PPA, and ESA public hearing scheduled for the week of November 6th, I'm really not certain that I could get anything out to the parties any earlier than the 10th.
Did you file a motion to vacate the hearing in that case?
We did.
Well, there were no protests in that case, right?
Correct.
And there was no intervention in that case.
Correct.
And that's case, we're talking about case number 23-00251 UT, right?
Yes, sir.
So I would, if you have any work at all, it would be extremely light. We're using the co-hearing presider, co-presiding hearing examiners in that case as well, because that was one of hearing examiner Michael Smith's other cases. So I wouldn't worry too much about work that you would be required in that case. You might be asked as part of a order granting the motion to vacate the hearing, you might be asked to provide a proposed decision in that case, though. So that would be the work, the kind of work that you might be expected to do in that case, potentially. So what if we move the date here to still circulate by the 10th, but move the date to the, well, I know how busy everybody is, and you're going to have additional work that you haven't seen yet, these parties. So we have the intervening Thanksgiving holiday as well. So could you possibly get the proposed decision filed right before Thanksgiving on the 22nd? That work? And still circulate, say, on the 13th?
I could meet that, yes.
Okay, so we would expect, would that work for the parties?
Yes.
Okay, so the requirement for the first post-hearing brief submission shall be PNM shall file the proposed recommended decision on or before November 22nd, 2023. And PNM will make its best efforts to circulate a draft via email, a Word version of the draft, to the parties and the parties only by the 13th of November, 2023. Briefs in chief, then will be due December 8th, 2023.
Mr. Hearing Examiner, I have a big brief due, very big brief due on that date.
In what case?
It's a Upper Flat Mine water rights case before the Office of the State Engineer. We had a 3-week hearing in August.
Right. So you're saying that anything earlier than that would be too difficult as well, obviously. Because I would move it up, actually, I'd rather move it up to say, you know, earlier in that week, but is that what you're suggesting, Mr. DeSalen?
Mr. Hearing Examiner, I think I'm probably suggesting that it get pushed back. But I would much rather it be pushed up than on the same day.
Okay. You do have co-counsel as well, right? Listed in the case?
On the water rights case, no. On this case, yes.
Yes, on this case. I'm afraid if we move this too far back, we're going to run into problems getting this board before the commission. Hearing Examiner Lundin, help me out here. What would you rather see?
I mean, I'm sympathetic to the parties here. Before we started talking about this, my goal was to get cracking on an RD immediately. I mean, I think a proposed RD is also helpful, so help me check my work. But you know, I was hopeful to get this case off my docket before December. But if anything is happening throughout December, it's going to get pushed for me at least.
It will get pushed.
Yeah,
that's my prediction.
Yeah, it doesn't seem like it's possible to finish this before December. So,
nor does it have to be.
Yeah. So, I mean, we're looking at a final order somewhere in late January, February. So,
right. So,
as far as the dates of briefing and proposed RDs, I defer to the parties on that. What works best for them?
Okay, so let's make it. We're pushing it out here, but the reason I'm comfortable pushing out here is just doing triage. Because other cases besides this that I'm aware of, and I'm aware of many, have either statutory deadline of the end of the year or the biggest looming deadline, January 4th, 2024 in the rate case. So with that in mind, let's, if there's no objection, and Hearing Examiner Lundin, correct me if I'm wrong, let's make the deadline for briefs in chief December 15th. Does that work for everybody?
I'll make it work.
And then response briefs, 2 weeks from then would be December 29, 2023. Is there any objection to that?
Nope.
No.
Okay. And so the briefs in chief will be due December 15th on or before that date. And then response briefs to the briefs in chief will be due December 29th, 2023. And we would expect that the briefs in chief would address any problems that the parties see with what PNM filed in terms of the proposed recommended decision, if any problems. I don't anticipate any, but I'm trying to make it so that there aren't problems with it by allowing the parties to provide comment and then PNM to make appropriate adjustments to the proposed recommended decision. Now, the final post-hearing submission is that bench request that we issued, bench request 1. When might PNM be able to file its response?
Mr. Hearing Examiner, would Monday the 23rd be acceptable? So next Monday?
Monday, October 23rd?
Yes, sir.
Yes, that would be acceptable.
Okay.
So
I would add, Mr. Hearing Examiner, we're going to have to actually go out and ask certain of our implementers. So we don't have 100% control over this, but we'll do our absolute best.
Okay, and if you need additional time, consider it, a little additional time, consider it granted for that.
Mr. Verhul, since it's my bench request, I didn't see an urgency for it. So if you wanted to include it in your brief in chief, that's fine.
Oh, okay, thank you. We will.
Well, we'll keep it at October. I keep hoping these will work. Anyway, we'll keep it at October 23rd for now, but if you need additional time, consider it as hearing examiner Lundin indicated.
Okay.
Consider it granted.
Understood.
So, since we're not going to, we've got a kind of a sort of a squishy date there. Responses to that bench request shall be filed within 10 business days of PNM's filing of the response to the bench request. And that's consistent with rule 1.2.235K, the additional evidence rule. Any questions?
Mr. Hearing Examiner, with respect to circulating the proposed RD, I presume you would like me to include the 3 parties who were excused from participation in the hearing?
Yes.
I will.
Yes, please. They are interveners. They agreed to, by being excused from this hearing, they agreed to the schedule and all the requirements herein, but they are on notice that they're, for instance, that they've got 10 business days from the date of your bench request response, yours being the company's, to file any reply to that bench request response. Because we're not going to issue, this is the briefing order that we're issuing orally from the bench. So are there any other issues to address?
Not from PNM, sir.
And that this is about the case in general. So PNM doesn't have any issues to address before we close the hearing? Okay. Attorney General?
No, sir.
CCAE?
No, sir.
Western Resource Advocates?
No, thank you.
Staff?
Nothing from staff, sir.
Thank you. Hearing Examiner Lundin?
No, sir, nothing for me.
Very well then, with no other matters to address at this juncture of the proceedings, this hearing is concluded. The evidentiary record is closed except for what the commission has required in terms of the bench request response. And this matter is taken under advisement. Thank you all. Appreciate your participation in this hearing. This hearing is concluded.
Thank you.
Thank you.